matter, my lord, Lordship was kind enough to hear out this matter substantially. My lord, relating to appointment of chief manager IT. My lord, what happened? The state authority, Lordship, was kind enough to direct the state authority to file their report, my lord. They have filed their report. After filing of the report, liberty was granted to us, my lord, to mention this matter. My lord,
For what?
for final, my lord, adjudication.
For final hearing.
Hearing, my lord.
You want the matter to be mentioned 2 days prior to the vacation?
My lord, just now, my lord, we have received their report, my lord. Lordship given them
Yes.
one ultimatum and directed them to file their report. On 2 occasions, they have missed it.
The report has not been filed.
Yes, my lord,
It has
filed.
been filed.
2-3 days back, my lord, they have
Yes. So
handed
it
over.
has to be done now.
My lord, if that case. In that case, my lord,
What in that case?
I think, my lord, the law substantially taken up for hearing.
Yes.
Lordship would kind enough, my lord, to dispose of this matter. That is
When?
why I'm trying.
When to dispose?
No, my lord. Time is very limited, my lord.
So try to understand.
Admitted.
You
Yes.
are not a junior member that you will make such a submission before the court to take up a hearing matter 2 days prior to the vacation.
Hearing was concluded almost. So that
Maybe.
report of the state authority.
Yes.
Madam,
Deep
may I please to mention one matter, my lord? In person, I appeared in CC 14 2023. The matter was disposed of by your lordship on 3rd. That is a contempt matter on 3rd May, where your lordship was granted me to make challenge. The order dated 17th November 2020. Only 6 months the order was passed. They have not given me any notice. Now, my lord, I have submission is this. The liberty may be given to challenge the matter by delaying condemnation of delay, and subsequently I went to the department concerned for getting certified copy. Unless the certified copy is not given me, I cannot make in appropriate taken step in the appropriate form. So I am praying for the direction may be given to the department concerned to give me the certified copy in this matter. That is the order.
There is already direction for issuance of urgent certified copies. Follow it up. No order. Yes.
Being leave to mention the
Madam,
move the matter on urgent basis, my lord. Regarding the unauthorized construction being approved by the chairman, only the chairman of the Purulia municipality.
Unauthorized construction.
Unauthorized approved by the
What
Purulia
is
municipality by
that?
imposing fine.
So it has been regularized by imposition of fine.
There is no provision,
Permission to
my lord.
retention. Yes. So file it. No urgency.
My lord, the urgency is
Nothing.
they are
What
trying.
is the correction?
My lord, the Regent Park police station has got gone down as Regent Park station, my lord.
My lord, under compelling circumstances, my lord, you're mentioning one matter. In a matter, my lord, where your lordship was pleased to direct the municipality to find out whether there is the portion to be demolished or not. The municipality has filed a report that that to be demolished. My lord, but they cannot execute the order, but they cannot demolish the portion because of the fact the unauthorized persons staying there, they are restraining, my lord. The portion may be collapsed any day, my lord. I am seeking your lordship leave to move the matter before the vacation, my lord, in the appellate side, my lord.
Before the vacation, during the vacation.
Before the
No, before vacation, there is
then
no
my lord
time.
kindly give me leave to move.
Yes, leave to move the vacation bench.
My lord, great.
My lord was asking for the
In the
regulation
original appellate side.
whereunder, my lord, the mayor is authorized to approve a demolition order. Rule 5 of the.
Call the list, please. This is the shop room, UP
Yes, yes. My lord, inside that Dokkinapon complex.
Dokkinapon.
But it really establishes that the open passage has been blocked, converted into a showroom. It's the entire thing has been diluted a little bit, but the main thing is revealed.
Are you aware of the report?
But he was supposed to take out an application. He has
Yes,
not done that.
I was, my lord. It has been a firm stamp punched yesterday. I was
But
not able
maybe
to
too
print it
late
on
in the
paper.
day, my lord.
My application for my lord adding myself as a party is prepared, my lord. Unfortunately, it was not brought on record, my lord. I'm not aware of the report. I'm told, my lord, by my learned friend that the report.
Please wait in that case.
Yes.
According to the See, the executive engineers, they have very neatly surpassed this provision as to whether this portion is to be left open or not. They have mentioned that a perforated rolling shutter is there, a railing with the grill is there, the air conditioned machine is there, but whether this portion is to be kept open or not, that line is very neatly sidelined.
One of the LOT was in 1995, the UT Bradford applied before the authority for seeking permission to use that very portion that is in between their shops. That was because their shops were located there. The authority took a decision to permit them to use that portion on the condition that without hampering ventilation and air. And a letter was issued. The condition was not subject
You
to
file an affidavit.
But one thing, my lord, I was drawing my lord's attention to the building rules.
We will see to it. Please come.
So that offer was given, but no allotment was.
Very well. You mention all those things.
What has been done is a common passage has been converted, my lord, in a mercantile building with
But it is not.
shops on either side.
A report has been filed by the engineers of the Kolkata Metropolitan Development Authority. Signed on 8th May 2023. Stop. Let the report be filed by way of an affidavit. Prepared and served upon the learned advocate representing the respective parties by 16th June. Reply, if any, may be filed by 27th of June. Liberty to mention.
Now, one thing, my lord, they are
Mention everything.
operating 3 air conditioning machines from there. That cannot be done, my lord.
We will see.
My lord, and this is the affidavit taking exception to the report.
Affidavit.
Taking exception. Actually, there are photographs to the report.
You will file a substantive affidavit. You can file your exception there. Why here? Correction. Appearance. Your name is not there. Achha. There is a typographical error in the order dated 10th May 2023. Stop. The appearance of the learned advocate for KMDA has been incorrectly recorded. Stop. The correct appearance will be put the name of all the 4 persons.
My lord is
The department is directed to carry out the necessary correction at once. Rest of the order remains.
my lord will kindly give a date, my lord, after vacation. My lord.
Liberty to mention the dates within which the affidavits are to be filed is given. Thereafter you mention. Yes.
Petitioner, Your Lordship, there was illegal encroachment in front of my premises 21 Stand Road. Your Lordship, by an order of 10th April directed the corporation to remove the all illegal encroachment in front of my premises. That was done. But subsequently, after the KMC officials went away, again some illegal encroachment was occupied by some other persons. Your lordship was pleased to direct the officer in charge to file a report and to keep a strict visit. So as on date, there is no as such encroachment.
No encroachment.
No encroachment.
Very well. Ashu. The stalls which were set up thereafter, has they
Has
been
been removed.
removed?
Yes. As on date, there is no encroachment.
Learned advocate representing the petitioner as well as the police authority submits upon instruction that as on date, there is no encroachment on the footpath in front of the premises number 21 Strand Road, Kolkata 700001. Stop. The report filed by the police is taken on record. Stop. The officer in charge, Hare Street Police Station, is directed to continue vigil to ensure that the encroachers do not return to the said place. Stop. Writ petition stands disposed of.
Deeply obliged.
My lord, I beg to appear on behalf of the petitioner, my lord. My lord, this is the second time this writ petition has been filed. My lord, before I get into the writ petition, my lord, I tender an apology because
Did you file the affidavit of service?
my lord, affidavit was habitually filed within the course of the day, my lord.
We are
It
in
will serve.
What's KMC?
KMC
Claim shall
is
be
yet,
served, my lord.
no, but then his learned advocate is yet to receive. I understand. What is the issue?
Well, illegal construction, even after the municipal corporation authorities who have been stated to make a hearing, no hearing has been done. Forcefully, they are constructing, my lord. If your lordship kindly comes, if your lordship kindly comes to page number 29, press 20, corporation page.
Yes.
My lord, this was the earlier order, my lord. As the corporation has already taken steps, the last paragraph, my lord. In the matter, no further order is needed to be passed, save and except that the corporation shall act and proceed in accordance with law and dispose the entire issue raised by the writ petitioner and directed the court in order dated in 26th. Another neighbor also filed one writ petition against that building. Passed in the WPO number so and so and reached to the proceedings to be initiated in pursuant to the stop work notice to its logical conclusion. The petitioner shall also be heard along with the respondent number 12 to 16 and other interested parties. This was the order passed in our writ petition. And the earlier writ petition that was been filed by the neighbors, not just the adjacent building, another adjacent building. My lord, that is from page 30, my lord.
No, so what has happened?
Now again they've started, well, from page 33 will depict page 32, 33, they have again started. And lastly now, with date and time, my lord, it has been referred. With date and time in the photographs. And lastly, my lord, what they have done yesterday is, they have blocked our terrace.
Blocked your stairs.
Terrace, windows,
Terrace.
as well as the stairs. From one side that blocked the whole part. My lord, this is the photographs, my lord.
Let me see. Who is the private respondent?
My lord, I appear for the private respondent number 12 to 16.
But there's another, from another angle, there's the photographs. No hearing was been given. And on the other side, in
What
collusion,
is the space between the two premises?
there ought to have been, my lord. There was a space earlier, but
Now?
now of 4 feet something. Now they have constructed and they have blocked my window, my one door here, 2 windows, sorry, and the terrace upon that on my terrace. There are the brick walls have been constructed, and they will be going on construction to 1 more floor, as we have heard.
May I? Pursuant to the order, the corporation issued notice in proceedings under section 400. We participated in the proceeding. An order has been made regularizing the construction by and imposing penalty. Penalty has been paid by us in terms of the as-made plan construction is now going on. Now, so far as whether notice was given to my learned friend or she is suppressing the note or the client is suppressing the notice, that matter the corporation will be able to say, because I have no notice of whether they have been given notice or not. But proceeding in terms of the orders passed on the two writ petitions were held.
Let me see.
Yes. Wait.
And we were not given any notice, my lord.
Well, kindly see this is the order. Kindly excuse the fact that the second page is in landscape mode and not portrait. Now, my lord, in terms of this, the provision now is that I have to pay 50% of the fine upfront and 50% thereafter. I have also made the payments, my lord. Payment order
Are you aware of this order that has been passed? Order of retention. It
My
was
client is
passed
also here. I asked
in
her. I asked her.
November 2020.
No, my lord. We were completely in dark. We were completely in dark.
Pursuant to this, the requisite penalties have been paid.
And after, when the remarks are infringement and the laws have been violated merely by paying, they cannot block my egress, ingress or my.
Show me the payment of fees.
The first document would be dated 27 September. That is, my lord, 50% upfront that I have to pay. Then, my lord, 19th April is the demand and the receipt.
My lord, we were not been heard even once also before passing off this order. That was the order of this honorable court.
But that, my lord, is for the corporation to say whether notice was issued or not. That I cannot say.
Total you have paid 41,000.
No, total 82,000.
82.
82.
Where is the intimation that you have to pay this amount?
Malad,
The assessment?
the second document dated 19th April is the demand. The third document is the receipt. There are two documents dated 19th April.
Charges for regularization is mentioned as 41,570.
That is the 50% because first upfront 50% paid on 27 September. Without that, I can't even apply for regularization.
Yes. But
Yes,
then
and
the assessment has to be made on as a whole. It's not that you make half.
But what they do is when they generate the demand, they give credit to that and then they raise the demand for 41,000. That is for the whatever I have paid 41 and 41. 41 on 27 September, 41 on 19th April.
The construction at one point of time existed over there.
Yes.
No, my lord.
Yes, there was an existing 3-story building
And now you are raising a puja room on the top of that.
on the top of
three-story.
and we have restored the building. There has been a staircase that has been constructed. One additional puja room on the top has been constructed. Your lordship will see the demolition sketch along with in the first bunch. It's being done exactly according to that. These are old buildings, my lord. We've reinforced this by RCC columns.
In the name of reinforcing and restoring, they are constructing another part out there, and that is blocking my window. There's the existing window. If it would have been a wall, then
please come.
how could a window be there, my lord? We have 2 windows have been blocked, and there are walls around my terrace now.
Petitioner complains that construction is being made by the private respondents in such a manner that the windows of the petitioner are being completely blocked. Stop. Next. Learned advocate representing the private respondent submits upon instruction that the construction in question has been regularized and permitted to be retained, subject to payment of the retention charges. Stop. Receipt showing payment of retention charges amounting to rupees 82,000 and odd have been produced before this court. Stop. The order passed by the special officer within bracket building KMC on 2nd November 2022 has also been placed before this court. Stop. Next. Learned advocate representing the petitioner submits that no notice of hearing was given to them prior to deciding the matter. Stop. Next. The petitioner alleges to be vitally affected in view of the order of retention passed by the special officer building. Stop. Next. Learned advocate representing Kolkata Municipal Corporation is yet to receive instruction in the matter. Stop. Paragraph. From a perusal of the order of the special officer, it does not appear that the same was passed after giving opportunity of hearing to the necessary parties. Stop. Next. The court in the earlier writ petition filed by the petitioner, being WPO 490 of 2021, passed order on 31st August 2021.
My lord, WPO 490 was our writ petition, my lord, at page 28, my lord.
490.
490.
Upon the corporation to take steps in accordance with law. After giving opportunity of hearing to the petitioner. Stop. Next. Whether opportunity of hearing was given to the petitioner prior to passing the order by the special officer building is to be ascertained. Stop. Next. Since the petitioner has submitted that her windows have been blocked because of the construction that is being made, accordingly, the court thinks it fit to direct the executive engineer within bracket building, Borough 4 KMC, to cause a spot inspection upon notice to the petitioner as well as the private respondents to ascertain as to whether the construction is in any manner blocking the easementary rights of the petitioner. Stop. The report of inspection shall be produced before this court on the adjourned date. Stop. The executive engineer shall cause the inspection at the earliest, but positively by 2nd June 2023. Stop. Report of inspection shall be produced before this court on 9th June 2023.
Well, the corporation may also come back on the said date with the information as to whether they were given notice or not.
Yes.
And my lord, in the meantime, a stop work may be permitted, my lord.
No, my lord, that I am opposing.
The corporation shall also mention in the report whether prior opportunity of hearing was given to the petitioner in the proceeding initiated before the special officer building.
Obliged, your lordship.
But in the meantime, they will submit copy. Your copy has not been.
Yes, today, my lord.
He has been served, collected from your
But
client.
today only, that's not. Yeah.
May please, your lords. My lord, before going to the impugn order, can you hear me for 2 minutes? Hear, my lord?
Your lordship kindly see, my lord, whether the impugn order entire the impugn order has been given to you or not. In the supply copy, it is not there. Second page is missing in our record, in our supply service copy, and whether it is, my lord, in your lordship's brief.
No, not there. Not there.
1 minute. Private respondents 7 and 8.
We are, my lord, 7 and 8.
Oh, to me? Ja, Baba.
Corporation, Mr. Mukherjee.
কি এটা? আমি তো কনফিউজ হয়ে গেছিলাম, তুমি এরকম চমকাচ্ছ কেন আমাদের?
Yes.
মানে point is very simple. There is a notice under section 411(2). Dilapidated condition notice has been given. 411(2). 1, 2. Notice has been given. Necessarily means the building a dilapidated condition and the tenants or whoever occupied, they should be evacuated. So there cannot be any chance of inducting somebody in that building where the notice has been served. Am I clear to my lord?
Who are you?
I'm the neighbor.
Why are you so concerned?
I'm very concerned.
Why?
Because, my lord, I'm a next door neighbor. If it is allowed to construct, my air and light will go.
But then the building was there all along.
Gone.
And so
now
it will not be constructed.
It's constructed, but they cannot take advantage of the rule showing a fictitious tenant in the premises and get 50% FAI.
How are you bothered? And why should you be bothered?
But I am bothered.
No, certainly not. I don't think there must be some vested interest over there. Why? Suppose it is my premises. It is
So
in a
this
dilapidated condition.
This point was raised in a matter where, my lord, my client, I'm taking 2 minutes time. My client was from Mali Panchghara. This construction raised unauthorizedly.
Unauthorized
Wait.
construction.
He raised a complaint. Normally, promoter ask him, if you come again, I will send you somewhere. Then a person residing at Salt Lake filed a writ petition challenging the unauthorized construction at Mali Panchghara. The immediate point, first point is that the writ is not maintainable. At your instance, you are not affected.
No, that is different. The example that you placed is different from what you submitted in connection with the writ petition.
No.
I do not say you do not have a locus standi to file the writ.
I have the locus standi.
No,
So I can bring a illegal thing before my lord.
Illegality to what extent?
Any extent.
Any extent.
Any extent. If it is illegal. Extension is not very German. Then, my lord, the point was raised. It was argued before Justice Bosak, and his lordship, after 2 days hearing, upheld that no. A person,
2 days hearing, Justice Bosak?
Yes.
Very strange.
Yes.
He doesn't take more than 2 minutes.
2 days is hard. Then, my lord, judgment was delivered, upholding my contention. No, wrong. No. Upheld the contention of mine that no, a person who is a citizen of India has a locus standi to bring to the notice of the court the illegalities going on. That was appealed against, appeal court affirmed that.
Yes.
So if my lord find that there is an illegality and I am bringing it to the notice of the court.
Wait,
I
wait,
will
show me
request
what is the illegal.
what I'm saying, my lord. So in that building, there was no tenant. Now, if a new construction is there,
Again, a neighbor, how do you know whether he has tenants or not?
assessment book will show. I will come to the law. I will come to the law.
Registered document.
I'll come to the law. Kindly hear me give me 2 minutes time. There was no tenant. And after the notice of section 411, there cannot be any ground for induction. Anybody cannot induct in. So, my lord, they, under the rules, they have to get an FIR if they can show that there are tenants. That, my lord, 100% FIR is not a matter of joke. So they created documents to show that there are tenants. We move your lordship's court. Your lordship's court passed an order directing them to consider my case.
Show me.
My lord, kindly page the ball. Page ball.
His
order
is incomplete, my lord.
Yes, I know that.
Page.
161, your lordship's order.
161.
Page 240, incomplete.
আর কতবার বলবি এটা?
না, ওটা তো মানে
আর কতবার বলবি? আমি তো বলেছি ইনকমপ্লিট আছে।
order, আপনি তো
Yes, I will place it.
পাতা missing আছে।
You have a senior, please.
না, আমি আপনাকে বলছি
না বলিস না।
পাতা missing।
161.
Kindly come to 163. Entirety need not be looked into. The representation, first paragraph, filed by the petitioner is pending consideration at the end of the municipal commissioner. Without entering into the merits of the said representation, the issue is referred to municipal commissioner or is delegated to take decision on the representation that has been filed by the petitioner on 9th September 2022, strictly in accordance with law, after giving reasonable opportunity of hearing to the petitioner as well as the private respondent to produce all relevant documents in support of their claim, and thereafter pass a reasoned order and communicate the same to the parties. A decision shall be taken in the matter within a period of such and such. Forward a copy of the representation shall be made clear that the circular of the Kolkata Municipal Corporation shall not be made applicable in the facts and circumstances of the present case. Now, my lord, this is the order passed by my lord. On the basis of that, my lord, I repeat, two declaration was filed. One is, kindly give the page number. Declaration. One is 206, kindly come. No, it milbe na tomar sange.
Page number मिलेंगे। 97.
Kindly come to page 97. This is the first declaration. Correct that.
The basis of the order হচ্ছে কোটা।
My lord, kindly see this. This is, my lord, the affirmed document, affidavit. This is, my lord, notarial document, registered document, whatever that is there.
97.
97. Kindly see this. Kindly see the date. 6 September 18. This declaration was given by them. What is the contention there? See, Subhash Chatterjee, son of such and such, wife of such and such, by occupation housewife, both such and such. Kindly turn over who are the tenants. That is, said premises are occupied by the following tenants: Shukanto Roy, Ochinto Guin. But kindly mark this: Shukanto Roy, Ochinto Guin, ground floor, first floor, and area occupied also mentioned. This is the declaration on oath. And my lord, kindly come to second paragraph of that we have submitted a plan and application in the prescribed form for erection of the said building before the Kolkata Municipal Corporation for the necessary sanction, because the condition of the said building is not safe for habitation. They admitted for an 11 notice. Now kindly see the second declaration. 132. Kindly keep that in your lordship's hand. 132. This is dated. This is the date 5th April 2019. But the date I will get at page 136. Has Malusali got it? Now kindly come to the first page, or rather second page. 134. Same person is giving declaration. the declaration at the owners of such and such, Kolkata Municipal Corporation, what the said premises are occupied by the following tenants: Ajoy Mitra, Prasan Kumar Sharma. Kindly see earlier one, Shukanto Roy, Achin Guin. And kindly see the area, 151.11 square meter, 91.786 square meter. And here, my lord, it has been changed totally. So either of the two declaration are after, both the declaration after, my lord, 411 notice. So, and they say this is inhabitable. That's why, my lord, they are made a sanction plan, and to get an FIR, 100% FIR, they are creating tenancy, and this is the document. These are the documents. Now, while considering this, conveniently, my lord, corporation could not see two declaration. One declaration they have seen. Now, kindly see their representation. 178. They themselves have said that there are two declarations. 178. Kindly come to 182. 182. Kindly come to paragraph 7 at page 182. In the said representation, it has been internally alleged that after submitting the plan for construction, the undersigned had submitted a registered declaration dated 6 July 18, and that subsequently another declaration dated 5th April 29 had been submitted. This is admission, nothing more. But while corporation was considering our case in terms of a lordship's order, could not see this.
Show me.
Kindly come to 185. 185. Kindly come to subparagraph C. It is true that the undersigned sought benefit of Rule 142 of the 209 rules, while applying for sanction as they were entitled to do so under the law, that the building was old, dilapidated, and tenanted would appear from the notice under section 411(1) of the KMC Act, issued by the municipal authority to both the owners and occupiers, copies whereof are enclosed herewith for your ready reference. The undersigned duly submitted a registered declaration of tenants on 6 July 1990. Subsequently, due to change of tenancy, the undersigned duly submitted a fresh declaration dated 5th April 2019 containing the same name of changed tenants, and also engaged the LBS as per the notice of LBS agency.
So two notice,
Two notice, but while considering my representation, corporation only seen one declaration.
Where is the order of the corporation?
That one page is missing, that my lord, landed friend is.
Where is that?
That part is there.
Where is that?
That is not kindly, so that, no. 240. Kindly come to 240. That part is available.
Page 2 missing,
But kindly come to 241. One page is missing, it should be 242. Kindly come to the last concluding, just prior to concluding portion. Thus, it can, has Valaskali got it? Thus, it can be considered that petitioner in this representative such and such informed that two registered declaration in respect of non-eviction of tenants submitted by the parties private respondent, but submission made by the building department wherein it is revealed that only one registered declaration for non-eviction of tenant mentioning two names, Ajoy Mitra and Prasan Kumar Sharma, as tenants, and their electric bills are placed in the records, and the proposed area as mentioned in the declaration is equivalent to the area as mentioned in the plan and also in the registered declaration. So there is no misrepresentation made on behalf of the owner private respondents while obtaining the sanction plan at the above mentioned premises.
No, but then he took into consideration both the declarations. I
That he cannot consider only the declaration. He has to consider other documents. Where the documents kindly now it has come to the law.
These are not to be
It has
looked
come to
into
law.
in this petition.
My lord?
Not to be looked into in this petition. If you have any private dispute,
There is no private dispute. There is
then I
no
do not
private
see
dispute.
anything over here to
There is no
interfere.
private. Kindly hear me, my lord. Kindly let us look to the law. Kindly come to the, kindly take the rules or take the section. Kindly come to 411. Kindly come to 411. My lord is looking every day now. Kindly allow me to read 1 second. if any wall or building or anything affixed thereto be deemed by the commissioner to be in ruinous condition state or likely to fall or to be in any way dangerous, he shall forthwith cause a written notice to be served on the owner and to be put on the some conspicuous part of the wall or building or served on the occupier if any of the building requires such owner or occupier forthwith to demolish, repair or square such wall, building or things, provided that in the case of a heritage not necessary. 2. The municipal commissioner may, if it appears to him necessary so to do, cause a proper hoarding or fence or other means of protection to be put up at the expenses of the owner of such wall or building or the safety of the public or the inmates thereof, and may, after giving them such notice as the municipal commissioner may think be necessary, require the inmates of the building to vacate it. When the 401(11) notice contemplates the situation of vacating, considering it is a dilapidated condition, there cannot be any question of induction of a tenant on the building.
I don't accept your contention. Please come.
Then, my lord, another thing, kindly come to 171. Kindly come to 171.
Yes.
Well, kindly come to Roman 4.
Yes.
That in case of insecure dilapidated building, where owners of the building wants to avail the benefit of Rule 142 of the KMC building rules, an NOC from all the tenants cannot be submitted. Application may be proceeded if NOC formal list, that is 80% of the tenants, be submitted. Necessary amendment of building rules in this regard may be initiated. Then, my lord, kindly come to 3. That to assess the number of tenants and their occupation, IB records of the year of 2009 or immediately prior to 2009 is to be considered. My lord knows, if the some tenant is there, it should be recorded in the IB. Now kindly come to 150, the IB.
No, suppose it is not recorded and it is not updated.
Issues not to be
The
considered.
tenant is not raising the issue that I was over there and I have
That are
been
not
a
the issues to be
relative.
considered. People ask for the adjoining owner.
Please come.
These are not
There
the
must
issues,
be
sir.
limit to stretching your argument.
No,
You cannot
issues
stretch
cannot
your
be raised
argument
by-
to that extent.
So I am remediless.
No.
What is your Lucas?
Then, my lord, I am
The order dated.
kindly look to this 150.
The order
Kindly
dated
come to 150.
16th February 2023, passed by the Special Municipal Commissioner,
Kindly
Kolkata
come to
Municipal
151.
Corporation,
The IB.
allegedly in compliance of the direction passed by the court in WPO 2642
Please, Doctor.
of 2022, within bracket, Kalinath Dotto versus Kolkata Municipal Corporation and others, is impugned in the present writ petition. Stop.
So দুটোই তো record
The matter relates to premises number 4, Narendra Sen Square, PS Amar Street, Kolkata 700009, under ward number 40, Borough 5 of the Kolkata Municipal Corporation. Stop. Next.
তুমি কোথাও বলনি যে নেই কর্পোরেশন
By order dated, no, by the court in the earlier writ petition directed the respondent authority to consider the representation filed by the petitioner. Stop. Upon consideration, comma, the Special Municipal Commissioner rejected the contention of the petitioner. Stop. The said order was passed after giving reasonable opportunity of hearing to all the necessary parties. Stop. According to the petitioner, comma, the Special Municipal Commissioner failed to appreciate the contents of the two declarations filed by the private respondents by declaring the names of the tenants in the subject premises. Stop. Next. The petitioners contend that the names of all the tenants are not recorded in the inspection book maintained by the Kolkata Municipal Corporation. Stuff. The building in question being in a dilapidated and ruinous condition, there could not be any scope to induct new tenants, only for obtaining the complete FAR and avail the benefit under Rule 142 of the KMC Building Rules 2009. Step next. The petitioners specifically state that fictitious persons have been shown as tenants in the subject premises solely to obtain the extra floor area ratio. Stop. Next. The provision of section 411 of the KMC Act has been placed. Stop. Both the declarations given by the private respondents have also been placed in court. Stop. Upon perusal of all the aforesaid documents and upon hearing the submissions made on behalf of all the parties, it appears that the petitioner is stretching the case a bit too far. Stop. None of the tenants have raised any objection before the Kolkata Municipal Corporation regarding evicting them without the due process of law, or regarding not allotting equivalent space in the newly in the construction to be made. Stop. The petitioner, being the neighbor of the subject premises, cannot raise a issue, ought not to raise an issue with regard to the number of tenants that may be inducted in the subject premises. Stop. It is always for the landlord to take a decision as to how many tenants will be inducted in the subject premises and the area of tenancy to be allotted to them. Stop. Next. It appears that the private respondents filed 2 declarations giving details of the tenants and has obtained the floor area ratio by availing the provision under Rule 142 of the Building Rules. Stop. Next. The court does not find that the special municipal commissioner acted in any manner not permissible in law. Stop. The order impugned is not liable to be interfered with. The writ petition stands dismissed. Oh, the police report filed by the officer in charge, Amar Street Police Station,
Affidavit service.
dated 17th May 2023, and the affidavit of service filed in court be written with the records.
Hope my lord is not annoyed. Hope my lord is not annoyed for doing bad matters.
Nobody knows after the vacation where the bench will go.
And for the petitioner, this writ application is preferred against the inaction on the part of the KMC authority to consider the representation of the petitioner.
Where is the service upon the private respondents? Both?
6 and 7.
6 and 7. Very well.
I have filed the affidavit.
Yes, yes.
The petitioner before your lordship is the lawful owner. of a premises being number 6A Tony Badi Lane. Well, the mother premises was 6. Subsequently, we purchased a portion of the property, which was subsequently divided from the main building. It was renumbered as 6A. It is a 2-story building. And the remaining portion, a small portion, well, standing on a quantum of land, only 1 kata 4 chodaks land, 1-story building. Well, subsequently, what happened, my lord? They, in the year 2010, all of a sudden, they started demolishing our veranda. Well, first, on the first floor level. Well, we lost complaint. Well, on the basis of the complaint, well, a regular suit was filed in the civil suit for protection of my civil right. That is pending. Well, what happened in the November 2022? They once again started demolishing not only the veranda, but a major portion of the roof of the building, well, without taking any care of the structural stability of my building also. Well,
The total is, how much total area is how much? 1 kata is yours,
I'm now 1 kata 5 chidaks.
is yours,
Yes, and he's 1 kata 4 chidaks.
separate.
Separate premises.
So how
no,
can
no,
some-
no, premise, mother premises.
Mother premises is 1.
6.
Yes,
My premises is 2-story,
yes,
and he's 1-story.
right.
1-story. Your lordship kindly to
Is
cut
there
something.
any partition, demarcation wall?
No, no, one. Join
Nothing.
adjacent to each other. Mildly, your lordship kindly take trouble to page 32, annexure P6, photographs. Everything will be clear to your lordship. What is going on? Well, kindly. Not only that, well, in violation, well, building rule 61, there must be some exterior open space. No open space, nothing of the sort. Your lordship kindly take trouble to photographs without taking any care and without taking any
Yeah,
precaution.
yes.
Several orders have been passed by the Learned Trial Court, City Civil Court.
Huh.
Their prayer for injunction have been rejected. They have come before this honorable court.
Well,
Division
corporation
bench.
was in a
One
partner
minute,
party
1 minute,
there.
Just a
1
minute.
minute. one
Corporation
minute.
was in a
I'll
party.
hear you. Yes,
In the division bench has been disposed of
yes,
without any restraining order.
right. So that
I am-
means you will go and demolish somebody else's property.
No, it is
No.
my property. Kindly appreciate the orders of the honorable court.
No, no, I'm not going to look at the
That
orders. Page 32 of the writ petition, there are certain photographs.
Photographs. This
is
is
your
my
building.
premises.
Is this your building?
Both the premises are side by
Adjoining
side,
each other.
adjoining. There is
Right.
a space and there is a my boundary wall and
No.
I have obtained a sanctioned building plan. I am raising my construction.
That is
No, that does not mean you will go and demolish. I can see some demolition, part demolition, these
No, I
sunshade.
have not
and
seen
well,
this,
next
sir.
photograph,
me see.
next photograph, well, next
Let
photograph.
me see, let me see.
This is my building.
They have started demolishing different portion of my premises.
My premises is dilapidated 1-story premises. Their premises is 2-story or 3-story.
Yes, the 2-storied building, the sunshade has been demolished. Why?
Why-
Hanging
no,
veranda,
no
hanging
concept.
veranda is demolished,
That
hanging
is the
veranda.
subject matter of the title suit.
What
That
is-
is pending before
What
the Learned-
mean? What is subject matter of the title?
that is projected illegal veranda of the petitioner.
No, well, that is with regard to my
That
civil
is
right.
projected
Civil
illegal
rights.
veranda of the petitioner. My lord,
My lord.
kindly see the
Did
orders.
did the trial court give you leave to go and demolish the illegal veranda? Is there any order?
That is the subject that has not
That
been
is the
decided.
subject matter that is to be
It's
decided.
pending.
How could you demolish it?
What? I have
What?
not demolished nothing.
Yes, yes, my veranda.
My premises I have demolished.
No, no, no. Malas, your lordship,
Kindly.
my
My
lord,
lord, kindly
it is evident from the
orders.
photograph. It is evident from the civil court photograph. My lord, my,
This is the third time I have obtained sanction plan.
no,
from
why,
the
that is why,
2010.
that is why.
Nobody is restraining you from raising construction in accordance with the sanction
Yes.
plan. That does not mean you will go and demolish somebody else's property.
How it can be ascertained that I am demolishing their
Yes,
premises?
Photograph
How-
speaks so,
photographs.
photograph speaks so.
Photographs.
You have already demolished my hanging veranda on the first floor
Mm.
level.
Now, whether the hanging veranda is within his portion or not.
No,
who
my
knows?
lord,
Yes.
my lord, my lord.
Kindly let
My
them
lord,
see
first photograph.
whether the veranda is
Evidence
their
there,
veranda.
evidence, yeah, my, your one-story
It is
building.
projected. Sir,
My lord, they are one-story building. Where from they are getting
that is
veranda?
a petition. They have
Where
already
from?
stated their veranda is resting upon my premises.
No, no, and it is a adjacent premises. Your
Sir,
one,
it is written in the writ petition.
it is one-story building.
The petitioner complains that the private respondents are raising construction in such a manner that the projected veranda in the first floor of the petitioner's premises has been demolished. Stop. The petitioner has annexed photographs to evidence that the projected veranda has been demolished at the instance of the private respondents. Stop. Objection filed against such illegal demolition in the hands of the private respondents is pending consideration. Learned advocate representing the private respondents submits upon instruction that the projected veranda has been constructed illegally by the petitioner. Stop. The place where the projected veranda has been constructed falls within the property of the private respondents. The issue in question is pending adjudication before the learned civil court. Stop. There are several orders of injunction passed by the learned court below. Stop. The petitioners failed to obtain any order of injunction restraining the private respondent from raising construction in accordance with the plan sanctioned by the corporation. Stop. Next. On a perusal of the photograph annexed to the writ petition and the submissions, and upon hearing the submissions made on behalf of all the parties, it appears that there is a dispute as to the ownership of the place where the projected veranda has been constructed. Stop. The petitioner claims that the same has been constructed within his portion of the land. Stop. The private respondent denies the aforesaid contention and submits that the construction has been made illegally over the land of the private respondents. Stop. Next. It will not be possible for the corporation to decide as to whether there has been any encroachment by either of the parties at the time of making construction or at the time of demolition of any construction. Stop. The corporation is only required to ascertain as to whether construction is being made in accordance with the plan sanctioned or not. Stop. Next. A civil suit is pending consideration in the learned court below. Stop. It will be open for the petitioner to highlight the issue before the, to ventilate the grievance before the pending suit, before the learned civil judge in the pending suit, and obtain necessary order therein. Stop. Next. The private respondent will be at liberty to raise construction in accordance with the plan sanctioned. Stop. The executive engineer of the concerned borough shall cause periodic inspection to ascertain as to whether the construction is being made in accordance with the plan sanctioned or not.
My lord, only one thing,
Petition
Lordship.
stands disposed.
My lord, only one thing, my lord. It is our specific case. The construction is being made in violation of Rule 61 of the building rules.
Yes.
Your Lordship, kindly direct to go consider.
The petitioner alleges that the private respondent is raising construction in violation of Rule 61 of the Kolkata Municipal Corporation Building Rules 2009. Stop. If a specific complaint is raised before the executive engineer of the concerned borough, the same shall be taken into consideration in accordance with law after giving a reasonable opportunity of hearing to all the necessary parties. Affidavit of service taken on record and the report filed by the officer in charge, Bortala Police Station, signed on 17th May 2023, be also written with the records. Mr. Mukherjee, without the brief.
No, no, still,
I have honored with judge like that.
No, it's nothing that.
Bother about.
No,
no, still he is
it's
interested.
because it is because of the assistance that the bench gets from the bar. That is the reason. Yes. Call the next matter, please.
Lordship, I'm appearing for the petitioner.
Yes.
Your Lordship, in this matter, after the filing of writ petition, there has been some occurrence of subsequent event. So in this regard, the petitioner would like to place that documents before your Lordship. And for that, he wants to file it through the supplementary affidavit.
What are the subsequent developments?
I have to take instruction from my senior in that case. Because I know that
It is not your knowing it. When you are making submission, you should be prepared to that extent to
Your Lordship.
answer the preliminary issues that have been raised.
I knew
It
this
is
will
you
come up.
submitted.
I knew this will come up. It's my mistake. I
Yes.
admit that. But ma'am, your Lordship, it is actually vital for the adjudication of the proceeding.
What is the issue? What are the new facts that will be vital? Why will the court grant you that leave? The court is required to be satisfied whether these documents, whether these events are required for the purpose of effective disposal of the writ petition.
I understand, your
There
Lordship.
may be many issues.
I understand,
Right,
your
but
Lordship.
whether each and every fact will be relevant that the
I
court has to
understand.
consider.
I
And the court will consider only those documents which are there on record.
Right.
Then what is to be done? What was the prayer in the writ petition? Are you
praying
aware?
Yes, I am aware of the case.
What is the prayer in the writ petition? Where is your file?
Yes, I have.
Check up. What is, let me see. What is the prayer in the writ?
Your Lordship, kindly come to page 22.
Yes.
Over here, we are at a writ petition, a writ in the nature of mandamus, commanding the respondent authority, the men, agent and servant, and associates in particular of the Chief Inspector of Factories to grant clearance certificate for conversion from factory to non-factory in respect of premises number 21/1 Radhanath Chaudhary Road. C. A writ of and or in writs in nature mandamus, directing responding authority and the main and agent or assigns to the cancel, withdraw the impugned notice being AACS XYX.
Yes, then what? So, what is the prayer?
Pray, your Lordship, that there was a land and
prayer, not the facts. Prayer is
yes,
to issue
we are
permission
actually
for conversion. Right?
We are praying for the conversion so
What
that
is the subsequent fact that has come up? Has conversion certificate been issued? Has it been rejected? Then what is the subsequent fact?
I haven't been updated.
Yes. Please come. Learned advocate representing the petitioner seeks time to take further instruction in the matter. List after the vacation, after the ensuing summer vacation.
Grateful.
Next time, be more
I will be fully
prepared.
Lordship.
My lord. My writ petition. Now, petitioner number 1 is a society. The petitioner number 2 happens to be the secretary of the petitioner number 1 society. Matter pertains to a property at R.N. Mukherjee Road. Now, there are 3 issues. The first issue is, my lord, till 20.
Where is the service?
Yes, madam. Affidavit of service, my lord.
When did you serve?
Yes, my lord. We have
When
served.
did you serve?
We have served on the 16th of May.
Yesterday.
No, this is the wait a minute. Just
Are you there?
I have instructed to appear, but no
No copy has been.
No, my lord, we have served, my lord. My lord.
Yeah, you may have served, but it is yet to reach the learned advocate. What is the urgency? Can we post it after the vacation?
No, my lord, I will be pressing for an interim order. If my learned brother doesn't have a copy, I will just give him
Then
my
you
copy.
Come tomorrow. Let him go through it at
Yes,
least.
let him take an instruction, ma'am.
No, not today only.
No. My lord will record, my lord, that I have given him a copy.
No, nothing to record.
Affidavit of service be kept on the record. ma'am.
Nothing. No recording at all.
I will. Wait. হ্যাঁ ও কপিটা দিয়ে দাও তাহলে কালকে মামলাটা হবে।
Lordship, I beg to appear on behalf of the petitioner. Lordship, my instruction is petitioner do not want to proceed with this matter. I have received the instruction from the petitioner. This is the notice. So I'm praying for non-prosecution.
I beg to appear on behalf of the state.
Are you the advocate on record?
No, ma'am, she is expecting a baby. She is not able to present.
And the letter has been addressed to?
To advocate on record. So that may submit.
देखिए কোথায় গেল প্রদীপ? এই সময় কেউ যায়? Are you there for the state?
For the statement.
আসুন। Not press করে দেবেন। Communication. Record the appearance of the state. Give your name. Very well, order passed.
Malad, I'm for the petitioner, Malad. It is just for a correction, typographical mistake, Malad. It is reflected in page number 2, paragraph 4. Malad, it is written teacher. Instead of teacher, it will be employee, Malad.
Tell me what are the errors?
Malad, only one error, Malad.
Yes.
It is in paragraph 4, page 2. Malad, it is teacher. On the part of the teacher, it will be an employee. On the part of an employee.
All the three matters?
One matter.
Oh,
only one matter, Malad, number 2.
No, yesterday two. না, অন্য দুটো আছে।
Well, I am for the Barakpur municipality. Well, our staff inspected the premises as your lordship directed. And also there is a direction.
I am for the respondent number 6.
Was inspection conducted? Are you aware?
Yes, my lord, I have persons gone there.
Yes.
That matter, the advocate did not release the papers.
What happened?
May I hand it over the report?
আমাকে একটা কপি দেবে?
হ্যাঁ দিচ্ছি।
Give me the report.
হ্যাঁ, এই নামগুলো দিতে বলছি।
চিঠটা দিল কই?
নামগুলো দিতে বলছি।
এটা দাও না, আমাকে একটা কাগজ দাও। আরে কাগজ দাও।
আপনাদের হয়ে কোনো উকিলবাবু আজকে দাঁড়াবেন কি? নাম বলবো? নাম বলতে হবে না, ওনাকে দাঁড়া করালেই হবে। Will you enter appearance?
Yes.
Did you file the wakalatnama?
No, my lord. So, lordship permits me, I file it soon.
Yes, please do. Are you aware of the facts of the case?
Yes, my lord.
What is your submission?
My lord, I'm not aware of what as per the petitioners, they are stating that on the 12th this month they have received a notice that the inspection will be conducted on the 13th. But on the 13th, after reaching the venue, there was no such inspection, and only at 2 p.m. when the notice stated that inspection was conducted at 12 o'clock. At 2 p.m. the corporation authority approached them and asked them to sign a particular document. And after inquiry, they were told that the inspection was conducted in their absence in some other time. Sorry.
No, yours says they are present.
1 minute, 1 minute. Yes?
No, my lord.
Yes, please say. Yes, madam, please. What is the submission? The inspection was not conducted. No?
The notice for the inspection was taken for the date of 13th this month at 12 o'clock.
Yes.
But as such, the inspection was not conducted in their presence.
In their presence, it was conducted in their absence.
Yes.
What do you mean to say in their absence? I can see it is recorded that the petitioners were present over there. আপনি উকিল বাবুকে এনগেজ করেছেন তো, আপনি আর বলবেন না। যদি উনি না থাকতেন আমি আপনার কথা শুনতাম। Yes.
আমাদেরই বরঞ্চ শুধু ভদ্র মহিলা ছিল।
Until the 12th, they were present in the venue. On the 12th, the
12th was not the date of inspection. Date of inspection is the 13th. Your client was present over there. And the wife of the petitioner resisted the men and agents of the municipality to enter into the premises for proper inspection. Why is it so?
এই, সেটা লেখা নেই।
We are claiming that the entire inspection was conducted in their absence.
You take instruction from your client outside the courtroom. The court is not a privy to whatever your client says. Have you followed? I can see from the report that the petitioner has constructed a room in the common space in the western side of the building. How was this constructed? You are not aware. Circulate this report. Let us see.
I already handed over.
You handed. Take instructions, come back on the next date.
Partition deed, 3 parties are there. Separately.
Partition deed is there.
Yes,
I
yes.
got it.
Yes, my lord. And roof is
I
mine.
got it.
Roof is yours.
And my lord, that's why, my lord, on the previous day,
Also,
I made an
three
objection
holdings separated.
that the
Malad,
REIT is
in
not
terms of-
maintainable.
And
It's a
plan
civil
also, my
dispute
lord,
and that REIT is not
plan
maintainable. That's why,
also
my lord, I
handed
made this.
to our engineer, my lord.
Very well. File a report. You also file your opposition. We can see.
Yes.
Report filed by the chairman, Barakpur Municipality, dated 16th May 2023. It's taken on record. Stop. Copy of the same has been circulated amongst the parties. Stop. The learned advocate, now the petitioner as well as the private respondent will be entitled to file their respective affidavits. Apropos the report filed by the municipality. Stop. The affidavit shall be prepared and exchanged by 16th of June. List on 21st June 2023, marked for orders. Stop.
My lord,
Next.
affidavit means affidavit in opposition, my lord.
Whatever you have got to say by way of an affidavit. Acha. By order dated 2nd May 2023, the chairman of the Bar Council was directed to forward certain instructions, forward the details of one Mr. Topon Roy, learned advocate. Stop. The order of the court has been communicated to the chairman, Bar Council. Stop. The report of the chairman is awaiting. Stop. Next. The chairman, Bar Council, is directed to take prompt steps for compliance of the direction passed in the order dated 2nd May 2023. Stop. A report shall positively be filed in accordance with the direction passed by the court on the adjourned date. Stop. Let this order be communicated by the Registrar General to the Chairman, Bar Council.
Okay. All right, I'm highly obliged, my lord.
Actually, leave granted.
এইটা পড়ে থাকলো
Leave
এই,
granted
পড়ে থাকলো কার?
to the newly engaged advocate of the petitioner to file wakalatnama in the department in the course of the day.
আর আসবে 21 সালে।
Court, my lord, I am led by Mr. Shomo Mojumdar, my lord. He is engaged in another court, my lord. I am praying for short pass over, lordship.
I'll
Short
place
pass-
it after the vacation.
No, my lord.
Very short Passover.
My lord, then my lord, I praise my lord.
Please do.
My lord, this is a old building, my lord, almost 100 years old, lordship. My lord, building is tenanted, my lord. This is a second round of litigation, lordship. In the first round of litigation, my lord, before this honorable was filed, lordship, directed the Kolkata Municipal Corporation to take steps necessary, lordship. This is a tenanted premises. Ground floor is a tenanted, lordship. We are agreed to accommodate them, lordship, after
You are the
reconstruction-
landlord, owner.
lordship.
Yes.
My lord, this building is now extremely dilapidated situation and it is collapsing, lordship.
So what is to be done?
My lord, kindly direct the Kolkata Municipal Corporation or ask my lord to demolish the building and allow me to construct a new building, lordship. This is my.
Did you approach the authority?
Lordship.
What has happened?
Yes.
Let me see.
But what are the requirements of the
No, but then submission, I don't know what is there in the report. Submission is that the building is ruinous, they have applied.
They have submitted their building plan on earlier of it was there. There was a
Building plan comes later on.
That is the reason that he is not posted in the fact. My lord, it was there, my lord, a promoter will act from there, constructed this the tenants will be relocated and after construction they will be placed. But for that, accordingly, my lord, it was there. Days together the matters were. Then, my lord, ultimately an order was not pursued there too, the building plan was submitted. Now, the paraphernalias have not been complied with. That is the reason why the building plan is pending sanction. You will also kindly come to second page of the report. Second paragraph. The building plan was submitted by the recording of March 2018 as per provision of 142 of all necessary documents have not submitted as per Rule 4 of the KMC building. Because my survey observation report, deed of deed from owners paid, etc. Since of the tenants and occupiers are not being submitted also as per the carrying on. That says this is the plan proposal portion. This is the position. If those are complied with, it will be acted upon accordingly.
My lord, I have this.
Please come.
But I am handing over my copy.
The matter relates to premises number 2, Rajbihari Avenue, Kolkata 700026. Stop. The petitioner alleges that the building is a very old one and in a ruinous and dangerous condition.
My lord, I can produce the photographs, lordship.
Who is denying the fact? Nobody is denying.
My lord, actual facts is that my lord, tenants are not giving no objections, lordship.
What will the corporation do? Go and throw out the tenants? What is to be done? Say.
Building will be collapsed, my lord, and casualty may cause, lordship.
Whoever stays over there will face the brunt. What can be done?
My lord, kindly fix this matter at 2 p.m, lordship.
Not at all. The petitioners intend to demolish the old construction and raise a new construction thereon. Stop. The petitioners are, however, not being able to demolish the building despite the fact that the condition is very ruinous and portions are collapsing because the tenants are not agreeable to vacate the premises. Stop. The petitioners have already submitted a plan proposal before the corporation seeking sanction. Stop. From the report filed by the engineers of the Kolkata Municipal Corporation, signed on 13th May 2023, it appears that the plan proposal was submitted on 9th February 2018 as per Rule 142 of the KMC Building Rules 2009. Stop. All documents as per Rule 4 of the KMC Building Rules. For example, survey observation report from KMC, NOC from KMDA, registered declaration for non-eviction of tenants, deed of gift for corners play, etc. has not been submitted. The details of the tenants/occupiers of the building have also not been submitted. Stop. In view of non-submission of all the relevant documents, the department is not in a position to process the plan proposal for sanction. Stop. Next. The report clearly mentions that the building is a very old one, partly 3 and partly 4-storied, occupied by several tenants/occupiers. Stop. The building is used as residential and commercial purpose. Stop. Portions of the cantilever have collapsed, and there are other dangerous portions in the building which may collapse. Stop. Some of the dangerous portions have been demolished by the Kolkata Municipal Corporation by engaging the demolition agency. Stop. Next. From the report filed by the Kolkata Municipal Corporation, and upon hearing the submissions made on behalf of the parties, it appears that the petitioners, being unable to vacate the premises, is trying to take the assistance of the corporation to vacate the same, so that the building may be demolished for raising new construction. Stop. Next. The Act, the KMC Act and the corresponding rules provides the mechanism as to how the old building is to be demolished and as to how fresh sanction can be obtained. Stop. It will be open for the petitioners to take necessary steps in accordance with law. Writ petition stands disposed of. The report dated 13th May 2023 be retained with the records. Stop. A copy of the same has already been handed over to the learned advocate representing the petitioner.
My lord, I have obtained the fire sanction. My lord, I have obtained the fire sanction, my lord.
So,
My lord, kindly
with the
direct
fire
me to-
sanction, what is to be done?
ওদিকে যাবো?
But I beg to appear on behalf of the petitioner, my lord. This is my affidavit of service. My lord, pursuant to the direction passed by this honorable court, my lord, one allegation was there, my lord, regarding the illegal construction without leaving mandatory open space. My lord,
Is there any private respondent?
now, my lord, page 56, my lord, once takes up. It's my lord's order. Internal page 2 of the order, page 56.
Yes.
4th paragraph, not the penultimate paragraph, the direction was given. The writ petition is accordingly disposed of, directing the respondent number 1 or to delegate and consider and dispose of petitioner strictly in accordance with law after giving opportunity of hearing. So, my lord, kindly takes up the next, my lord, page 58, the impugned notice before your lordship. Here, my lord, the corporation have found that up to G+2, there is a deviation from sanction. And, my lord, 3rd floor is without sanction. My lord, I have stated, my lord, in paragraph 12 of my writ petition, that specifically, so far as regards the 3rd floor is concerned, I have not constructed any 3rd floor. It's palpable, my lord, paragraph 12 of my writ petition kindly once looks at. It's an availment made on affidavit. That third floor entirety not constructed. And so far as regards the deviation with regard to G+2, I do have sanction as per the order of demolition. G+2, no inspection has been made, no notice of inspection, even no ex parte inspection was being relied upon. What is the deviated portion up to G+2, which do have my sanction, that has not been described. And regarding third floor, paragraph 12, I have specifically stated, no third floor is being constructed by my client.
Very well. Yes.
I have to take instruction regarding that. But fact is this, my lord, may direct that we will make a further inspection and specify in the presence of both the parties. And both the parties with the name. The writ
There
petition was
has
filed.
been a complainant.
Yes,
The writ petition is there on which your lordship are directed. Both the parties may be directed.
Yes.
And specify the deviations.
The
And
notice
also
of
to specify whether there
self-demolition.
is a construction regarding third floor or not.
Yes, that's all. That's true.
Notice of self-demolition issued under section 177 within bracket 5 of the Howrah Municipal Corporation Act 1980 by the Assistant Engineer, Howrah Municipal Corporation, dated 17th April 2023, is impugned in the instant writ petition. Stop. The matter relates to certain construction at 11/2 Baje Shibpur Road, Ward number 31, Howrah 71102, under jurisdiction of Howrah Municipal Corporation. Stop. A complaint was lodged before the Howrah Municipal Corporation alleging unauthorized construction being made by the petitioner herein. Stop. The court, in a writ petition filed by one Shomir Kumar Talukdar and others, passed order on 28th November 2022 in WPA 23625 of 2022, directing consideration of the objection filed against such unauthorized construction. Stop. Next. The order impugned has been passed allegedly in compliance of the order passed by the court. Stop. Paragraph. It is the specific contention of the petitioner that the construction in question has not been raised up to the third floor level. Stop. The impugned order mentions about construction of third floor without a sanction plan. Stop. According to the petitioner, sanction has been obtained for construction of G+2 storied building. Stop. The petitioner contends that construction has indeed been made up to the G+2nd floor. Stop. The next argument by the petitioner is that the deviation made in the G+2 storied structure is not specified in the impugned order. Stop. The petitioner is not in a position to identify the portions which have been allegedly held to be unauthorized. Stop. Next. Upon hearing the submissions made on behalf of the parties and upon perusal of the materials on record, there is nothing to show that the impugned order of demolition was passed upon inspection of the property. Stop. The petitioner asserts that inspection was not conducted prior to passing the impugned order. Stop. Without a proper inspection being conducted at the instance of the corporation, it will not be possible for the corporation to ascertain the extent of unauthorized construction. In view of the above, the instant writ petition is disposed of by directing the concerned officer of the Howrah Municipal Corporation to cause a fresh spot inspection upon giving prior notice to the petitioner and all other necessary parties, and especially the complainant. Within bracket S, complainants.
We have no instruction as to whether the inspection has been done or not.
It does not appear.
Had it been such, my lord, then third floor would not have mentioned, my lord, in the order. My lord, third floor has not been constructed by my client.
Acha. কি বললাম? To cause upon notice to all the necessary, especially the private respondent. Yes. A fresh spot inspection report shall be circulated amongst the parties, clearly specifying the
Deviations.
extent of the unauthorized construction which are required to be demolished / removed by the person responsible for making construction. Stop. Such spot inspection shall be conducted at the earliest, but positively within a period of 4 weeks from the date of communication of this order. Stop. The spot inspection report, along with the spot inspection report, along with the follow-up steps that is to be effected by the petitioner, shall be mentioned and communicated within a fortnight thereafter. Writ petition disposed.
So thereafter,
The impugned order dated 17th April 2023 shall be kept in abeyance till a fresh order is passed by the Howrah Municipal Corporation in this regard.
Grateful. Grateful.
Service taken on record.
My lord, on last, yesterday, my lord, I directed the KMC to file the report, my lord. My lord, in this matter, I am led by Mr. Learned Senior Subir Sanyal, my lord. Only for the report that was called, my lord, they were supposed to hand over the report on earlier, 21st April, and we were filed to exception within 4th May, and the
Let me see.
But I'm handing over, I'm late as I submitted yesterday, my lord, because of the difficulty. এটা দিয়ে দেন তো জজ সাহেবকে।
Are the private respondents appearing?
Yes, my lord. I am appearing with the private respondent led by Mr. Osim Kumar Rai.
Yes, what is your submission?
My lord, my small indulgence, my lord, kindly see, this was the earlier writ petition, the report that has been given, an earlier writ petition was filed, similar report was given. My lord, my learned senior appeared in this matter and called for a report to be placed disclosing the nature of unauthorized construction, because this matter was all, earlier writ petition was filed. They have filed a D case, but nothing has been done, my lord. It has been kept in abeyance, my lord.
My lord.
The report that my lord has called for in the order, my lord, that was to give the disclosing the nature of unauthorized construction at the subject premises and steps taken to deal with such unauthorized construction. They have already told us that a D case has been lodged, but nothing till date, my lord. That is what my learned senior had submitted, my lord.
Where is the sketch?
No, it's not there, my lord, because it is filed in the, my lord, special officer building. It is not with the department. Special officer building, and he can approach the special officer building, my lord, by an application. Get the documents, my lord. Ask my lord to make an application before the special officer building.
Again, my lord,
A hearing has been done
Yes.
under section 400. Was the petitioner given any opportunity to place the case before the hearing officer?
My lord, the hearing.
My lord, my last order, my lord, last order was, my lord's last order was, a copy of the report shall be prepared and served upon the learned.
I can see what the order is.
Yes, my.
What is your submission?
My submission is the petitioner filed a suit before the city civil court, and
I am not concerned with the suit. Tell me about the nature of construction that you are raising.
in this matter, Osim Kumar Rai is reading me.
Please come.
My lord, kindly keep the matter, adjourn the matter, my lord.
A report has been filed by the learned advocate representing the Kolkata Municipal Corporation, signed by the sub-assistant engineer within bracket civil/building, assistant engineer within bracket civil/building, and executive engineers within bracket civil/building, Borough 4 and 5 on 16th May 2023. Stop. Copy of the report has been circulated amongst the parties. Stop. Learned advocate representing the petitioner and the private respondents seeks time to take further instruction in the matter. Stop. List after the ensuing summer vacation.
My lord can give a date, my lord. Any date, my lord.
After summer vacation, it will come on the 5th of June.
Any date, if my lord fix it.
5th of June.
5th of June, my lord. Grateful, my lord.
I beg to appear on behalf of the petitioner, my lord. Your lordships were pleased to, my lord, pass an order, my lord, directing the concerned executive engineer, my lord, to inspect the, my lord, premises, my lord, so far as the unauthorized construction is concerned, and to file a report, my lord. We have not been supplied with a copy of the, my lord, report, my lord. Would your lordship's pleasure to, my lord, direct my learned friend to have a copy of this, my lord, report, so that we can, my lord, if necessary, my lord, we can file an exception to the report, my lord. If it is found, my lord, that, my lord, correct picture has not been depicted.
The report. Is the private respondent here?
My lord, 11 to 17, my lord, I am representing.
18. How many are there?
11 to 18 are the private respondents.
Yes.
Notices were served upon your clients. They did not appear, so the court was compelled to direct notice to be served upon you. Why is it so? Why is your clients not
My lord, this is
taking
probably, my
steps?
lord, 6 or 7 times, my lord, the petitioners are approaching before this court, my lord. Previously, it was, my lord, denying access to the building. Thereafter,
That cannot be a ground when
By-
your
by-
lordships
by
were pleased
place,
to,
my
my lord,
lord, two
directly, lord.
orders.
Everybody is to comply
Prior
with that.
orders passed by the coordinate benches, my lord, the petitioner was warned
That's an
A
allegation.
coordinate bench by this honorable.
What is the case of the petitioner?
My lord, petitioner's case is that, my lord, unnecessary construction or substantial additional alteration has been made.
And
So
by
far
the
as,
private
yes, my lord.
respondents?
Yes, my lord. So
Very
far.
well, please
yes.
wait. Pursuant to the order of the honorable a joint inspection was held according to the report on the 12th of April. Are the parties aware of the same?
My lord,
Lord, we were
28th
present.
of April, my lord, I have been instructed that on 28th of April, there was an inspection. And my lord, no unauthorized construction was found, my lord.
And
That,
while
let me see, let
My
me
lord,
see. I am in the very first line.
my lord.
Was there another?
second floor. কিন্তু বলতে পারছি না। হুম, হুম।
The report says that a construction is there, but it's pretty old.
My lord,
So
may,
there
may,
is no recent new
so, my lord, I
construction.
cannot, without my lord, seeing the report, my lord, I cannot make any comment, or I cannot, my lord, take exception to the report, my lord. I may be permitted by your lordships, my lord, to have a copy of the report so that we can file an exception. And if it is found, my lord, I can refer to the page number instantly, my lord, page number 41, my lord. Where, my lord, it is found, my lord, that open space is there, my lord. And, my lord, that, my lord, all the, my lord, the sanction plan and other documents were, my lord, submitted, my lord, to the person who was, my lord, competent officer who was making inspection, my lord. I do not know whether those have been, my lord, referred to in the report or not. If it is not done, my lord, or its subjective satisfaction of the, my lord, inspecting authority, this has been done, my lord, kindly have a chance to, my lord, file exception to the report, my lord, after supply of the copy.
A report has been filed by the learned advocate representing Kolkata Municipal Corporation, signed by the executive engineer within brackets civil, building department, Borough 1, on 8th May 2023. Let a copy of the same be circulated amongst the parties. Stop. The parties.
সবাইকে দিতে হবে, so that's enough copy.
একটা কাজ করুন, লিখুন। Copy of the same has already been handed over.
No, my lord, I have not received, my lord.
You will receive it
My-
just now.
My lord, a copy দিয়ে দিন।
Has already been handed over to the learned advocate representing the petitioner as well as the private respondents. Stop. The parties will be at liberty to file exception to the said report by 16th June 2023.
My lord.
Let the matter appear in the list on 27th June 2023, marked for orders.
Deep lowest.
I have already.
Respondent number 18, you got a
I have
copy?
received. Yes, my lord, I have
Get a
received
cop-
it just now.
Did you get a copy? Very well.
Deep lowest.
Shall I post it prior to that?
Yes, my lord, it can be
That
posted
gets
before,
22nd of June.
grateful.
I am for the petitioner lordship. On the last occasion, your lordship directed the learned advocate of the municipality to serve a copy of the opposition to me by 1st May, but till date I had not received the copy, your lordship.
First way itself, the advance copy has been sought. I don't know why my lord.
Who received it? Show it to her. Shikha.
জানি না কি নাম আমি জানি না দেখো তোমার ওয়াচিং গেট on first of
Your Lordship, it may be the peon of the office. He has not informed me, Lordship. I am apologize for that. Actually, my father-in-law expired on the 23rd of April. That why I have not attended the office for some days.
Very well.
Can I give you a further copy?
Give it an
Peon
opposition.
আমাকে দেয়নি copy. একটা copy দিয়ে দিন।
Filed by the municipality in court today is taken on record.
Stop করে দিয়ে দিন।
The time to file the affidavit in reply by the petitioner is extended till 16th of June. List on 27th June marked for orders.
একটা copy দিয়ে দেবেন না? হ্যাঁ।
Do one thing.
না, না, but I think-
Do one thing. List on 30th of June marked for hearing. 30th of June marked for hearing.
কত?
30th of June for hearing.
Much
And
obliged.
2 weeks after vacation, you file your exception.
Much obliged.
দিকে চলে যায় সরে যায়। My lord, I'm for the petitioner. My lord, I'm for the petitioner.
Yes.
My lord, your lordship had passed an interim order on 22nd March 2023 and had directed, my lord, if your lordship takes page 4, directed, my lord, the corporation to file a report disclosing the facts and figures pursuant to which immediate action was called for under 400 subsection 8 of the KMC Act, my lord. My lord, they have filed a report. We had, my lord, been permitted to file an exception. We've also filed the exception application, my lord. I'm ready with my application unless they want affidavits, my lord.
Exception application.
I've taken an application out for exception to the report, my lord.
Washing of the.
Why a separate application?
My lord, that can
We
be,
do it by way of filing affidavits. Why an application?
my lord, maybe treated as an affidavit, my lord. In that case, my lord, it's been filed in that manner, my lord. It's been filed as an affidavit
An
with a
application.
prayer, my lord. There's a prayer, my lord, taking
Yes, the
exception.
prayer is there. In the affidavit, there is no prayer, only the statements and everything is
The prayer
is
is
the
there, my lord, in
application
the application, my lord.
application.
Well, the similar point, on the, it is a relating to 408. And the similar point was raised in another matter that is pending and the hearing is going. I hope it may be adjourned for some days. The result will affect this matter.
No, no, that one attack.
And also, my lord, they are not filing an opposition to my exception. If they wish to file an opposition,
They have filed an application.
I filed the application in case they want to give an
Not
option.
setting aside the,
Setting aside the report, so lordship gave us leave to take out any, in case they want to file any affidavit, lordship kindly. Otherwise. Yeah, কোনো affidavit দেবেন, কোনো affidavit?
করতে চাইছে অন্য কোনো operation। কি? তাই না, বলবে যে similar point আছে, যার সঙ্গে tag করতে।
Tag করছেন।
একদিকে
একজন কি
be tagged হয়ে যাওয়া ভালো। Actually, I don't mind if it's tagged because I would
I
rather
am
be.
not tagging it. Better adjourn করছি for sometimes the hearing is going on, that result is binding up.
কোথায় hearing হচ্ছে?
Report number 6.
Court number 6.
আজকেও দুটোর সময় মামলাটা হিয়ারিং আছে, চলছে কদিন ধরে মামলাটা, I don't know. Just you not.
তাহলে আমরা ওখানে জয়েন করে যাবো তাহলে ওখানে।
Please come. An application has been filed by the petitioner.
খুবই ঠিক নেই বলে।
Challenging the report dated 20th April. on behalf of the respondent numbers 1 to 4. Within bracket KMC. Stop. Next. Acha. The Kolkata Municipal Corporation. Listen, if this is challenged, then the cause of action completely changes.
But Lordship's first order provides that, my lord, Lordship, because Lordship had called for a report and Lordship had
Yes.
given us leave to file exception to it.
Not by way of an application. Exception can always be filed.
By way of an affidavit, Lordship can treat this as an affidavit. Lordship, after all, it is a firm.
Otherwise, they will file another exception.
Lordship, I understand.
Be a never-ending process.
So, Lordship said a exception to be filed by.
Yes, exception.
Can be Lordship can treat this as an affidavit.
The said application be treated as an exception to the report filed by the Kolkata Municipal Corporation. Stop. The matter is required to be heard. Let the same be included in the list of hearing on 16th of June 2023.
If they want to give any reply, let them. Otherwise, I don't want them to come next day and say, I want to give a reply. If they wish to give a reply, let them.
What reply will they give? Certainly, there is no scope for filing any reply.
My lord, with deepest respect, my lord, either report stands or not stands,
Yes.
either law stands or not stands. So
What
what's the scope for?
to reply?
Yes.
Lordship, the interim order is there till tomorrow. Tomorrow.
The interim order that is subsisting. What is the interim order?
That not to demolish.
Not to demolish.
Because they are given 401 notice 1 year back. After 401 notice, they did not take any steps to initiate second 400 subsection 1. My lord's judgment is there.
The interim order that is subsisting in the matter is extended till 31st of July 2023 or until further order, whichever is earlier.
Item 11, I have 34.
The petitioner is not here.
But perhaps my learned friend appeared on behalf of the petitioner.
Are you there?
Yes, I am.
Then
Not calling me. I have not heard.
what is the matter?
But implementation of the order of demolition.
Therefore, implementation of demolition of the order passed. by-
Requisition sent to the police.
But on
Then
the last occasion, my lord was pleased to direct the corporation to produce the
final order.
the order in the appeal that the private respondent has preferred. But your lordship will
appeal.
kindly take the report, Mala. There is no order because pursuant to the amendment of the act, the mayor has no authority. Amendment took place on 6th of June, my lord. And the appeal, the alleged appeal, my lord, it was preferred on 10th. That is 4 days after the amendment. So by the virtue of the amendment, the mayor has no authority, my lord. So, my lord, no order is yet been passed in the appeal.
So you are required to implement.
But I am required to implement the order.
Please implement.
My lord.
Yes, please.
There are several suppression of video.
What is the suppression?
The building was experience was completed in 1971 after the purchase in 1961 by the father of the petitioner. And thereafter, they were living the body fighting against the fighting against the body. The husband has died, father-in-law has died. In 1990, about the roof, two rooms have been constructed. There
Till then, no objection, nothing had happened. My lord, in 2008, my lord, I stated in my evaluation, 2008, my lord, the roof has been dilapidated. But the calculation of the rainwater, my lord, roof has been, my lord, renovated. There comes the objection. My lord, the objection is that, my lord, the original complaint has not been brought in.
Original complaint has not been
Annexed, my lord.
annexed. It has not been annexed.
It was the encroachment, complaint of encroachment of an undivided share. My lord. No partition has been commenced, my lord. In the repetition, my lord, presently, my lord, one copy of the partition plan, my lord, has been annexed. My lord, kindly look at my
Page.
my lord, kindly look at my lord, page 35, my lord. There you also find, my lord. A partition plan has been annexed, my lord. My lord, without there been any partition till that, my lord. In this guise, is other proceedings, my lord. Partition and, my lord, the demolition of the entire building. It is only complaint of encroachment of an undivided share. My lord. Internal arrangement, internal construction has been made, my lord. No outer. The roof has been renovated.
You and the petitioner both reside in the same building.
Same roof, my lord. Same roof in different mess.
Yes.
After the demise of
The building is the same.
my lord, same building. Same building.
All right. You are in the top floor.
Now, both of us in the ground floor, my lord.
The building is how many floors?
Only 2 rooms has been constructed in the first floor. In my portion, my lord,
All right.
according to the petitioner, the partition has commenced. None, my lord. Never, my lord. We are in joint base, jointly sharing the property, my lord. My lord, only in 2009, when the roof was in dilapidated condition, my lord, rainwater was percolating, my lord, I have renovated that. There comes the objection for the encroachment of the portion of the petitioner, my lord. My lord, I have taken that plea, my lord. If your lordship kindly look at page 35, my lord.
Do you have the copy of the opposition?
Yes. In the plan, my lord.
Corporation also has a copy of the opposition. Yes. Which portion?
Page 35, my lord.
35.
My lord, in the affidavit, my lord.
Yes.
Or in the writ petition, my lord.
In the writ petition.
The plan which has been annexed by the writ petitioner.
Yes.
It is alleged to be the partition plan. Page 35, P3. Writ petition. My lord, in the plan, if your lordship kindly looks at the right hand column, my lord, the signature of the owner. Only one signature, my lord. If it is partition, my lord, plan should have been signed by both the parties. And that too, my lord, if your lordship go down to the page, my lord, the right hand column, my lord, it is made of 15/12/2002. My lord, so far my instruction goes, my lord, I have stated in my affidavit, my lord, in 2002, there were 3 co-owners. There were after the death of the father-in-law of my respondent, my lord, the private respondent, my lord, he had left 2 daughters, his wife, and 1 son. I am the wife of my son, of the son, my lord. My husband has expired in 2011, my lord. In 2009 only, 8 only, when the roof was renovated, my lord, there comes the objection, my lord. My lord, it is only the objection for encroachment, my lord. My lord, the corporation has decided, my lord, that part of private dispute, my lord, by holding that unauthorized construction has been made. Well, it was the internal construction. No internal construction, my lord. I have annexed a page in my annex 1 sketch map in my affidavit, my lord. Kindly looks at how the property stands on the building. I have given the copy of the
page 16.
My lord. My lord, the property stands, my lord. There was no deviation, my lord. There was no illegality. Till then, my lord, it has been constructed in 1970, my lord. In 90, it has been fully completed.
He was in the Panchayat regime, my lord. My lord, it is not possible for the housewife, my lord, to produce the plan, my lord. At this stage, the petitioner would be the better person, my lord.
Picture of this.
Let me see.
Picture of the structure.
I have given the sketch map, my lord.
Yes, yes.
My lord, this is the fourth round of litigation, my lord. In the first occasion, my lord, the municipal authority has
Which portion? The newly constructed brick portion?
Newly constructed.
Newly
Without having
constructed.
permission, without sanction plan. That's why the municipal authority, municipal corporation has already taken steps.
over where, my lord?
Submission is 1990, the construction was over.
Correct. These are not the things.
Not correct.
Second, not correct. Secondly, my lord, things.
Let them adjudicate, my lord.
The joint,
When the age of the building, let them adjudicate, my lord. The age of the building, my lord. It is
The photograph that has been produced, is it incorrect?
my lord,
Show a copy
it is
to
the
it.
internal construction, my lord. In the roof, my lord, 2 rooms has been constructed in 2000, in
Listen,
1990.
This construction is not an internal construction. See the photograph. Is it the photograph? Is it the photo of the structure?
My lord, which one, my lord? The entirely. Floor. It is absolutely untrue, my lord.
This is not the structure.
It is structure, my lord. It was done in 1990. It is absolutely untrue, my lord.
What is untrue? The photograph is untrue.
My lord, the construction is standing, my lord. It is standing.
This construction was made in 1990.
My lord.
Without having sanction plan.
My lord, at the instance of the father and my lord, the petitioner and the husband of this respondent, my lord. There was no objection on that at that point of time. My lord, I have taken all these things in the memo appeal, my lord, which has been filed in the wrong way, my lord. But
When was the construction made?
Recent construction, thereafter case must start.
Not that, my lord.
The case is pending for more than 5 years.
So for 5 years, the structure is standing.
Another case has been pending before lordships. Now the last occasion after the contempt application, the municipal corporation already passed an order. Thereafter the contempt application disposed of. Now the come before this court is the only for execution of the order or the compliance of the order passed by the commissioner. This is 101.
You are for execution of page 101.
Yes.
Is the private respondent aware of the order of demolition passed by the commissioner in 2017?
My lord, that has been taken care of, my lord, and appeal has been filed, my lord.
No, but then appeal is non-est
My lord,
because
kindly looks at this order, my lord, an order passed by this coordinate court, my lord. How the corporation has dealt with, my lord, my matter, my lord. My lord, sometimes in October, my lord, they has assumed the jurisdiction, my lord, to decide the appeal in other cases, my lord. But in my case, my lord, even sometimes in February, my lord, my appeal was filed, no intimation. I have visited, several reminder was there. Nothing has been taken. Can you look at the order, my lord? In October, also, my lord, mayor has assumed the jurisdiction to decided the appeal.
Yes,
but in my case, not been done, my lord. No enforcement has been given.
Do it. The law does not permit the mayor to do.
It is so, my lord. It is so, my lord. My lord, I am not saying anything, my lord. Can you look at the conduct, my lord? The mayor has taken the care of the appeal.
Yes,
But in my case, it has not been taken.
That order has passed 2017.
It's a discrimination, my lord.
No, wait. Which portion of the order are you relying upon?
My lord, the second paragraph
of
that order, my lord, which have been given, my lord.
The facts are there in the second paragraph.
Yes, my lord, the second page. My lord, the second page. Fourth paragraph, my lord.
This error was challenged by the appellate authority and
On
the appeal is
30th October,
dismissed.
mayor had assumed the jurisdiction to decide the appeal, my lord. In other cases, my lord.
Assuming somebody has done something wrongly, can you seek negative
I am
equality?
not saying, my lord, the wrong which has been done, my lord, but the conduct, my lord.
What is the conduct?
Mayor was very much aware that he has the jurisdiction to decide the appeal.
He can
But on that point of time, it was not the case of the mayor that it was done wrongly. He was in belief that he has the jurisdiction. In my
Please.
case, it has not been done.
Please,
One
you
more-
cannot raise this type of submission in court.
Otherwise, my lord, in 2011 only, the commissioner has held that it is a private dispute. It is a private dispute, and that
Listen, as on date, I can see there is an order of the commissioner which is not challenged by
which is the
you.
third round. That is the third round. Private in preliminary round, my lord, having considered the.
Did you ever challenge this order?
My lord, I have challenged, my lord, in the appeal, my lord. My lord has the
Then-
jurisdiction to hear, my lord. Since the tribunal has been established, my lord.
Yes, tribunal has not been established, so you could have approached the competent forum.
My lord, I have approached after obtaining the 26th June order, my lord. After that,
Where
18.
is your petition?
my lord, in my affidavit, my lord, I have stated, my lord. I have given the copy, my lord. When, my lord, the order of demolition, after the appeal has been filed, the authority has come up with a self-demolition program that has been challenged in a writ petition, my lord.
Yes.
My lord, in the said writ petition, this coordinate bench, my lord, has held. Since the appeal is pending, no demolition further self-demolition order can be activated, my lord.
Now, the appeal has been held to be
My lord,
treated to be as non-est because the appellate authority before whom you went did not have the
that is why,
jurisdiction.
my lord, before I am before your lordship, my lord, to the
Where before your lordship, by which manner, where is the writ petition?
my lord, that writ petition, my lord, as of today, my lord, my appeal is pending, which is infructuous. But in fact, my lord, the tribunal has not been, my lord, since we do not have any, my lord, scope to counterclaim in the writ petition, my lord, I would have done so, my lord. My lord, my client, my lord, is not so much financially affluent, my lord. She is running her family by, my lord,
If she is not financially affluent, she can always approach the legal aid for service. But will that mean that the law will not be followed?
my lord,
It cannot be.
my lord, if your lordship kindly looks at the page 70 of the writ petition, my lord. Yeah, it would be clear, my lord. The corporation has taken the charge to decide the private dispute, my lord. With regard to the encroachment, no external construction, only there had been an internal construction.
They have unauthorized.
My lord, for that internal construction, no permission is required, only an intimation is required, my lord. My lord, I think there had been an intimation, my lord. Otherwise, it would have come, my lord, much earlier. But when the writ petitioner was there, living in the same premises, my lord, he would have objected to at that point of time.
You could have always sought for recalling the order of in your earlier writ petition if it was passed upon wrong submission or something. You did not do that also.
Page 70 last one.
If your lordship kindly looks at page 70 of the writ petition, my lord, it would be
Please
very much
wait.
clear. My lord, it was held by the my lord, the authority that it was a private dispute between two.
As regards private dispute, it is all right. But as regards unauthorized construction, the corporation can always take steps.
My lord, internal construction, my lord, within the periphery, my lord.
How can I say internal construction?
My lord, on the roof, my lord, on the roof, my lord.
That has been assessed by the.
All constructions on the roof becomes internal constructions.
My lord, at that point of time, I think so, my lord, a permission was there. An intimation was there. I am not in position right now, my lord.
Your intimation, nothing will do. Yes, the
My lord,
corporation.
let them help.
Please wait.
The quantum of.
As far as one of the appeal is concerned,
That is gone. Yes.
that the appeal was filed after 6th of February, and from 6th of February, that provision is there. And as far as the order is concerned, the lordship will find from page 102 that there is no discussion or no production of any sanctioned plan building scope with regard to the construction. And the only thing is that what has been directed on the private response is under this 90. That is 90 the power to require alteration of an existing building. So what has been said is that whatever portion is there, obviously there is no sanctioned plan, that part is to be removed.
The lordship will find that in the fifth last line in the order. In accordance with section 290 of the Regional Municipal Corporation Act, Polluka Chaudhary is demolished within 30 days from the date of issue of this order. The unauthorized structure by way of encroaching the portion of
Well, the encroaching of portion, my lord. Clearly, my lord. My lord, rule 11(2), my lord, provides, my lord, the internal construction, my lord. My lord, when the roof was dilapidated, that has been repaired, my lord. There comes the objection in 2008 only. For an encroachment.
Well, this is after getting after inspection. Order has been passed. From the findings of the that page 101 bottom two. And the Miller, the executive engineer of this corporation, after causing such inquiry, has filed a report dated so from which it transpired that Timothy Chaudhary, the private respondent, had made construction without scratch and encroaching the portions of the part from the ground floor to first floor.
How did this observation be returned?
Regarding encroachment, I
Hmm.
fact remains that even if all the points are taken by my learned friend, the private respondent, this in this situation, the regulation seeks cannot achieve.
Well, even in the original complaint of the petitioner, my lord, there is a allegation of encroachment, my lord, of her portion.
And see, the submission of the private respondent is also recorded that the construction started in the year 1990, completed in 2007.
My lord.
So everything is mentioned. The authority invokes 290, but then says to demolish 218, case is registered. Invocation of 290. 290 is not demolition. 290 is the power requiring alteration. Right? There is no scope for passing an order of demolition in section 290. Made construction without the sanction plan and encroaching the portion of such and such. This finding possibly could not have been returned by the commissioner. Please come. There is a corrigendum. 70.
290 shall be read as
Page
72.
72. Assuming section is wrongly written, but the observation finding with regard to encroachment, how do you get over it?
Not encroachment, the engineer should not have gone it. I cannot better that case from the bar. I will
Well, since the beginning,
Yes.
the first order of the demolition, there was an encroachment observation, my lord. Since the beginning, 2008, my lord. That has been challenged and altered, my lord.
Even then, the difficulty is that private respondents cannot challenge it.
Nobody is challenging it, but the court suo motu sees that the order is incorrect. So this cannot be implemented.
So far, the unauthorized
The
sanction plan.
petitioner seeks implementation of the order of demolition.
Private dispute can be resolved.
Implementation of the order of demolition passed by the Commissioner, Bidhannagar Municipal Corporation on 18th January 2017. Allegedly in compliance of the direction passed by the court in WP 12686 W of 2011 with CPAN 520 of 2014 within bracket Rupa Dasgupta alias Chaudhary versus Taposh Chatterjee, Chairman, Rajarhat Gopalpur Municipality. Stop. It appears that the Commissioner relied upon the report of the executive engineer to pass the impugned order of demolition. To pass the, not impugned, order of demolition. Stop. Next. The Commissioner, not the Commissioner, the executive engineer caused an inquiry and submitted a report mentioning that the private respondent made construction without sanctioned building plan, encroaching upon the portion of the petitioner in the ground floor to the first floor. Stop. On the finding of encroachment, the Commissioner opined that there has been illegal and unauthorized construction and accordingly invoked provision of 266 of the West Bengal Municipal Corporation Act 2006 and directed the private respondent to demolish the unauthorized portion, which was constructed by way of encroaching the portion of the petitioner in part. Stop. Next. The private respondent, being aggrieved by the order of demolition, preferred an appeal before the mayor. Stop. By the time the appeal was preferred before the mayor, the West Bengal Municipal Corporation Act 2006 got amended and the power of the mayor as the appellate authority was taken away. Stop. The private respondent, being unaware of the amendment, preferred a writ petition before this court, challenging the order of demolition. Stop. The court, being made aware of the fact of pendency of the appeal, directed the appellate authority to dispose of the same at the earliest. Stop. Later on, it transpired that the mayor was not the appropriate authority to decide the appeal. Stop. The said fact was not communicated to the private respondent. Stop. The private respondent was under the impression that the appeal was still pending. Stop. Next. As on date, what remains is the order of demolition passed by the Commissioner, Bidhannagar Municipal Corporation on 15th January 2017, which the petitioner seeks implementation of. Stop. Next. Upon perusal of the said order, it is very clear that the order of demolition has been passed on the finding returned by the executive engineer that construction was made by encroaching the portion of the petitioner. Stop. The executive, neither the executive engineer nor the commissioner of the corporation is the appropriate authority to decide the issue of encroachment. Stop. The corporation ought to restrict the consideration only with regard to unauthorized construction and not venture into deciding the civil rights of the parties. Stop. The private respondent asserts that the construction in question is in place from 2007 and the same is reflected in the order of the commissioner. Stop. It was for the commissioner to take a call as to whether the said construction was made in accordance with the provisions of law and whether after existence of the said structure for so many years, is there any requirement of passing an order of demolition? Stop. The corporation ought to steer clear of any private disputes in between the parties. Stop. Next. In view of the above,
I'm not arguing on that one. But the lordship seems that there is any wrong in the order. In aware for a certain period, and they can approach the right for our meaning.
why will we generate litigations?
I'm not trying to do so, but my explanation is not with me. These two parties are at loggerheads.
Answer. 1 minute. It has been submitted by the learned advocate representing the Bidhannagar Municipal Corporation that since the writ petition is not at the instance of the private respondent and none of the parties have challenged the order of demolition, accordingly, it may not be proper for the court to decide the legality of the order passed by the commissioner. Stop. Next. The court is of the opinion that on the face of record, the order passed by the commissioner cannot be substantiated in law. Stop. In such a situation, not interfering with the order and keeping the same in abeyance for abeyance to be challenged by the aggrieved party before the appropriate forum will amount to generation of a fresh litigation, which can be avoided if the impugned order is set aside at this stage with a direction upon the corporation to decide the issue afresh. Stop. In view of the above, the instant writ petition is disposed of by setting aside the order passed by the Commissioner, Bidhannagar Municipal Corporation on 15th. Please check up with this 15 or 18. 18th January. আগেও বোধহয় 15th বলেছি. It will be 18th of January 2017.
Yes, my lord, 18 January.
As modified by an order of original of 19 January 2020.
Modified by the corrigendum dated 19th January 2017. It will be open for the Commissioner, Bidhannagar Municipal Corporation to decide the issue of unauthorized construction afresh after giving reasonable opportunity of hearing to the petitioner as well as the private respondent for production of necessary documents in support of the construction made. A decision shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Affidavit in opposition filed on behalf of the private respondent be written with the records.
May I disturb your lordship at this hour?
Yes.
Next matter, my lord, there is a direction for filing report. Let them file the report and give a copy to us.
Thank you, sir.
Let me see the
If we
file.
accept the report, no exception. If you don't accept it, I'll give it time, so file an exception.
Let me see the file, please. A order.
Deeply obliged, madam.
Take back this order copy.
My
It's not required.
I am not appearing in the earlier matter. There is a grievance from the bar.
From the bar.
From in the judgment. The lordship had restrained generation of litigation.
Yes.
That is, my lord, against the fundamental right of the advocates.
To some extent, it has to be. What is your allegation in the writ petition?
My lord, your lordship's order is there.
You want me to read the entire order? Tell me in a line what is there.
It will be easier. 2 pages order.
Inspection to be held whether when my client is constructing, whether it is doing so upon keeping spaces, appropriate spaces or not. That is the
Earlier
referral.
report was not satisfactory.
That's the earlier report had come, which was unspeaking. My lord wanted now a detailed report to come.
Why is the original attendance sheet over here?
Annex
In
Let it be there.
Let it be there because there is also original sheet is also.
How many originals?
2,
I
3.
think those are not original. It's a copy, Xerox copy.
Original or original?
Acha. Inspection report filed by the executive engineer within bracket civil / building / borough 2, Kolkata Municipal Corporation dated 15th May 2023 is taken on record. Stop. Let copy of the same be circulated amongst the parties. Stop. The parties will be entitled to file an exception to the same within 16th June 2023. List 27th of June 2023 marked for orders.
Grateful lordship.
Please, everybody give your appearance.
Yes, yes. For own interest, they'll give. No problem.
No, but then other names are also coming. Those had to be deleted.
একটা আছে জেরক্স করতে হবে একটা ফর্ম
But Attorney, I am the petitioner in this matter, Miller.
Yes.
His lordship on the last occasion directed the municipality to file a report. Now, my lord, I have gone through the report, my lord. The problem is my advocate on record is suffering from an operation, my lord. So he has given me 2 documents, but I want to disclose this document by way of an exception, my lord. The sanction plan and the, my lord, comprehension certificate.
Where is the report?
My lord, I'm filing. So the point taken on the last occasion was that the order has not been communicated.
Yes.
On that day, we were not equipped with the tracking report. Lord, I'm not, since I do not know whether he's really wants to pursue the matter today or not, but if your lordship kindly takes page 17 pursuant to the second round of litigation, which Lord, the Joydev Noskar had, Joydev Haldar had come up saying that we are not implementing the demolition order. Lord, an order was passed by this honorable court asking the executive engineer to take steps. That order is at page 14. Another recent order was passed saying that the person did not remove the unauthorized construction, so he used to evacuate the occupiers within 4 weeks. This order appearing at page 17, your lordship will find that the dispatch is at page 20. এটা কি এরকম দেওয়া হয়েছে না এরকম লাগানো হয়েছে my lord, this is on the bottom side is Rabindranath Shikdar, bottom one, 4774, and my lord, the tracking is at page 22. Page 22. 4774 was delivered on 10th of February 23. So the order was communicated to the petitioner.
Is the petitioner supposed to demolish?
No, my lord, the petitioner was directed to both landlord and petitioner. To both persons have been served, landlord as well as the petitioner who is one of the occupiers. So, my lord, kindly see page 17. Under the facts and circumstances, the undersigned directs the private respondent, that is them in the erstwhile writ petition, to evict all the occupiers from the subject property within 4 weeks.
Do you intend to file an exception?
Lordship, because my lord, the whole order itself is, my lord, it's bad in law.
Then you are required to challenge it afresh. What can be done over here?
Now, my lord, so far this order is concerned, my lord.
What is your prayer?
My lord, prayer
Withdraw
is, my lord,
set aside 13th April 2023.
yes, my lord. 13th April, which has been,
that is page 69.
Yes.
69. Is it the same document as appearing at page
No,
17?
after page 17, this is a follow-up saying that you are directed to evacuate all necessary articles. Now, my lord, we had taken the point that they are challenging the consequential order of the corporation.
Not the main order.
That in that, when we made that submission, they said that this order has not been communicated to them.
Okay.
We have received this. That is why, my lord, your lordship directed us to file this report, not only to show this, but also to show the documents on the basis of which we have taken the decision.
But,
The
my lord,
earlier
but,
decision.
but, my lord, may I submit one thing, my lord? In the order, my lord, itself, my lord, it has been mentioned, my lord, that the alleged 6-storied building structural, according to them, there is no sanction plan. Nothing has been disclosed to them. But our specific instruction is, my lord, that everything has been submitted to them, including the my lord, the completion certificate, which has been annexed in this writ petition. The completion certificate, my lord, issued by the concerned municipality at that point of time, that has also been given. That is, my lord, at page, my lord.
Take a call whether to proceed or to file exception, because in that case, I'll go to the next matter.
In that event, my lord, kindly, I shall file the exception disclosing all these documents. Thereafter, lordship will, my lord.
Report in the form of affidavit filed on behalf of the Bidhannagar Municipal Corporation is taken on record. Stop. Copy of the same has been served upon the learned advocate representing the petitioner. Stop. The petitioner seeks time to file an exception to the same. Let exception to the report be prepared and served upon the learned advocate representing the respondent authority by 16th of June. List on 28th of June. Mark for orders.
My lord, some courts, my lord, have a notice outside the courtroom that not to have lunch inside the courtrooms. But this situation is not well.
Situation is?
That situation where we are supposed to keep the papers, my lord, it's not well.
The secretary is here. Why don't you tell him?
What to do now? If someone, my lord, come to, my lord, what to do?
What will the court do?
What to do? How, my lord, prevent, everybody knows, my lord. Now, my
No,
lord,
no, please, everybody may know it, but then once you take something, you should clean up that place.
now, my lord,
You
the
cannot leave
problem,
it that way.
my lord, that's why, my lord, the problem is, my lord, we require rooms. I have categorically, my lord, on many occasions discussed with the Honorable Chief Justices, my lord, kindly gives us a room so that I
Judges
can.
are not getting places to stay, to sit. You
The
see
rooms
in
are
the
not-
chambers. Then-
Yes, my lord, I have seen that.
But then tell the members
I
that to
will.
clean.
I will. I will announce.
Otherwise, see, they cannot keep their papers over there.
I will. Grateful.
রসগোল্লা খেয়েছে ছুটি আসছে 14, my lord, in this matter, my lord, I am appearing for the petitioner. Last occasion, the corporation is supposed to file the report. I am challenging. What is the steps taken there? File that for just file this just 14.
They said that it will take much time to complete the process of tender. And the work order will be issued in September, after September, after July. After September, after July, September.
September.
After September. Therefore, my lord, the petitioner do not have any grievance of being prejudiced.
You are saved. They will implement the work orders, if any, after September 20.
Because if subsequently they have what they have done, my lord, this is a border number 3, no? Border number 3. 7. Subsequently, my lord, after filing of this application, they have floated tender in border 9 and 9 and what is there? Completely change the criteria portion.
What is mentioned there?
Now,
no, but then that is not under challenge. In your
that's why, my lord, I want to challenge the same because there is reservation.
that is a separate with that is not.
No. For
Over
that
here.
reason, my lord.
Borough 7, September, you are saved. Please come.
May I have a copy of this?
Yeah, give a copy to him. Achha. The learned advocate representing the Kolkata Municipal Corporation has produced an instruction signed by the Deputy Chief Engineer within bracket Civil, Basti Department, comma, DG, Basti Department, and the Deputy Chief Engineer within bracket Civil / Executive Engineer within bracket Civil, Borough 7, mentioning that the tenders have been floated beforehand and the work order will be issued after September 2023. Stop. Next. The petitioner has paid royalty up to the second quarter, that is up to September 2023, and accordingly the petitioners will be
Two
entitled.
petitions, my lord.
Petitioners will be entitled to provide the maintenance till September 2023 for the period royalty has been paid. The petition stands disposed of. Same in the next matter is also same.
What's
Next matter is also same.
Same, my lord. It is mentioned both the
already been paid.
Paid বলে দিয়েছে তো?
And the other one is Boro 7 also.
Yes, yes.
Okay.
না মানে বড় wise.
Boro wise it's coming.
Item 16, I am for the.
Lord, item 16, Lord, I am for the request. Lord, the today, Lord, matter has been placed before the Lordship for implementation of the order. Lord, the demolition order was passed on long back. Lord, on last occasion, Lord, I undertook before your Lordships to pay the demolition cost, if any, raised by the municipal authority, and the Lord municipal authority was directed to make an inquiry and to exercise all the things and to get it done by 12th. But that was not done.
Demolition not done.
My lord, may I be permitted?
I'll hear the corporation first.
Lord, we had caused an inspection, and after the inspection was caused, my lord, as it has fallen from your lordship on the last occasion, that a notice to be affixed in the area, my lord. Notice was affixed. Thereafter, my lord, we received around 1,200 applications we have received, my lord. Everybody is saying that we are responsible for the construction, and let us be given hearing there too.
1,200.
1,200, if I'm not wrong.
Yes.
So, my lord, we are already in the process of issuing notices, my lord.
To 1,200.
Not to 1,200, my lord, just to identify primarily that who is the person concerned, my lord. My lord will kindly not take me amazed, my lord. This is a mandir, my lord, and this perhaps is now getting instigated with regard to the religious sentiments of the local people there.
Somebody is instigating them.
Yes.
You make an unauthorized construction and you place an idol over there, and then it takes the shape of a mandir and it cannot be demolished because an idol is over there. This is the submission.
Once again, not take me amazed, my lord. This has perhaps become the culture of the country now.
But then it should be stopped. If something is done incorrectly, somebody should stand up and say that this is incorrect and this cannot go on. Right? Take steps for demolition. The order is already there. Even after this, you issue notices, you receive notices from 1,200, 12,000 only for the protection of a construction which is illegal, irrespective of the fact whether it's a mandir, whether it's an educational institution or whatever. Any construction that is illegal is required to go. This should be the message.
My lord, it is falling from your lordships, my lord, but as it is the mandir, my lord, a judicial order so that we can arrange.
What more judicial order do you require? The court has already asked you to demolish it.
As well, my lord.
Everything
What?
has been given, my lord. But Lordship has given everything.
1 minute. Yes.
My lord, if for that matter, my lord, if there is a direction, my lord, because we will be requiring police assistance because
that order is
a
there.
matter of demolition, my lord, as my lord knows that in general cases also, my lord, when there is a demolition by the municipality, my lord, generally we go forward and seek police assistance. That is the general practice of the law, my lord. So, my lord, if there is a specific direction thereupon, my lord, perhaps that will assist us to comply with the orders in the letter.
But that direction
1
was
minute. Who are you for?
For the first time, I am appearing.
Why? Why for the first time?
Because I did not know, my lord. We came to know from the affixation, my lord, on the wall of the tiny temple. On behalf of the local people, I am appearing.
Are the local people parties in the writ petition?
For that, my lord, just for that, my lord, they have executed the bhoka, my lord, and they want to be impeded as a party respondent in these proceedings. One thing, my lord,
What is their interest?
Their interest, my lord, I am saying, my lord.
How much money is generated in that mandir?
May I be permitted, my lord? Your lordship, kindly give 1 minute, my lord, I will say, my lord. There was an altar.
There was?
Altar. Bedi.
Yes.
Since last more than 50 years, my lord, it is on the brink of a pond. It was on a brink of a pond. And the latest position says that it is still a pond. There was a banyan tree for more than 100 years, my lord, that was there. Initially, it was under the Gram Panchayat. Thereafter, it went to this
municipality, my lord. And thereafter it has come to Vidhannagar municipality. My humble submission, well, let the status of that particular plot be determined first by the municipal corporation. They should follow the procedure as prescribed in the West Bengal municipal rules.
What is the prescribed rules?
When my learned friend's client is claiming that they are the owner of that particular property. When they purchased it, what was the status of the property? Whether it is
All these
unauthorized
things,
construction?
all these things will be looked into by the municipality.
Well, the hearing should be held, and we have submitted our application there that I should be permitted to make our submission.
Are you the owner of that land?
They are also
What is your right?
Well, it is not on the plot of the petitioner. That is my.
What is your right?
Well, since last 70 years, we are offering.
What is your right?
That is upon their right is also.
Why don't you construct a mandir at your own place?
They also do not have any right over that property.
You construct a mandir inside your house. Let everybody go there and pray. Why on the roadside?
Roadside, my lord, if it is no man's land, my lord, if there was there.
How much money is generated over there?
No money is.
No money is generated.
No, this is not for that purpose, my lord.
For what purpose is it
Only
there?
for praying, offering prayers.
Go pray inside your rooms. Why over there?
Well, in this fashion, my lord, in this way, your lordship.
Yes, obviously.
Order,
Think
my
is
lord,
an
that-
unauthorized construction. The nature of the construction is not important. The use of the construction is not important.
Just a minute. Let the
Who are the persons standing at the back? Your clients? Who are these persons?
Yes.
They are the clients. Why? Live streaming is going on. They are not required to come here. Tell them to go out. They can see everything what is going on live.
One thing, my lord. Let it be decided whether it is unauthorized, authorized, whatever it may be.
It has been decided it is unauthorized.
Has it been placed before lordship?
Yes.
That we do not know, madam.
That is the reason, because
first
you are
time
not supposed to know. You are not supposed to know.
Affixation first time we came to know.
Yes.
And thereafter I am coming for lordship. For getting protection.
No protection to any unauthorized construction that is there.
But that effect, Millard, only not taking sides, Millard, but we also had written a letter to BLRO because, Millard, we wanted to assist the court with the whereabouts of the owners of the plot, Millard. The BLRO has not replied to us, Millard. We wrote to the BLRO on the 24th of April, Millard. This is the second time, Millard, we wrote. And Millard, before that, we also had written.
Corporation, the more you support these type of activities, things will go out of hand. People will not be able to walk on the streets. The cars will not be able to move. You have to say no to somewhere, to somebody.
Millard, on record, Millard, I submit that not only the officers of the court, Millard, but even the officers of the corporations are not in tandem with any kind of illegal constructions, Millard. Millard have seen, Millard, whenever we have any kind of that sort, Millard, we come and submit before the court, Millard, fairly, Millard. But the only difficulty, which as an officer of this court, Millard, I feel that this is a issue, Millard, where a lot of people have become involved, Millard, rightly or wrongly. That is perhaps a way, Millard, perhaps a thing, Millard, if Millard feels like considering.
According to the petitioner, who is the owner of the land? You are the owner of the land.
Lord, this is the picture. I am the owner of the land. Lord, regarding the title deed, I have annexed with my petition. Lord, the frontage, Lord, 34 feet, that is the frontage. Lord, around 10 feet that has been covered, and rest portion that has been covered by the mandir structure. Rest portion, Lord, the up to 3 or 4 feet from the land, Lord, they have made, Lord, the structure. The entire ingress and egress of my land has been blocked, and my landed friend is telling, Lord, that is the water body. Lord, right now, send any court officers from here, any advocate as a commissioner. And if any advocate comes to and report before your lordship, yes, there is a water body,
I am agreeable to that.
yeah, or there is anything else, Lord, I will withdraw my petition. Lord, same argument was made on when this order was passed on February 8. Lord, the same thing. Lord, the municipality has also the corporation also they made the same argument before your lordship. On that occasion, Lord, I submitted all the documents, including the Lord photographs. And after considering all the photographs, my lord was considered, Lord, this is the things, and the order was passed.
Where are the
Lord,
photographs?
absolutely. While I am
My lord.
agreeable to send any learned advocate to visit and report whether it
Whether
is a
there is-
pond, it was a pond, it is a pond or not. Submerged land, totally submerged.
Absolutely not. Lord,
At
I
present,
have
my
the
lord,
personal
totally
knowledge.
even. I have personally visited the spot, my lord. On that basis, I am making my submission.
Where are the photographs?
না না এগুলো কোথায় আগেরগুলো
আচ্ছা বলছে
Lord, this is the photographs which I placed before your lordship on last previous.
Show it to your learned friend also.
This is frontage person, my lord. They have erected boundary, and inside boundary, my lord, they have the land they are claiming to me. And that is totally a pond, my lord. I have personally visited. On that basis, I am making submission.
Which one is the construction?
Yes, Lord. এটা একটু দর্শক দিন
Show it to your learned friend also.
But this is the boundary wall. The part of the boundary wall has been blood enclosed by the boundary, and rest part from here to there, from this part to this part, but they have made the structure up to blood the 3 feet or 4 feet from the blood the grassroots level, and they are enjoying these things also.
2 feet
Is
wide.
this a, is this a,
Personally, I visited.
no, no, the photograph, is it of
not
that
necessary.
place?
I have been there.
Is
2
the
feet wide.
photograph of that place?
My lord,
Please check up.
Your lordship will find 2 feet wide and see 6 feet, 6 to 7 feet length. This is the teeny temple, my lord, what they are claiming. And behind this, they have erected the boundary wall. They have covered the entire plot. And inside the this boundary wall, my lord, there is a pond.
So why are you going? There is a Ganges behind the High Court. Does it mean that this is a water body?
We have not covered their land.
Lord, this is the land.
They have erected their boundary wall.
Strange.
They have covered their own land, my lord. Your lordship.
They have covered their, they have constructed boundary wall. It is perfectly, it is their right to construct it.
I am not
Then-
going on that point, my lord. My lord, what they are saying that you remove this. And they are the passages there. And there is not only one person, 4 partners are there. They have also, my lord, have a big gate, my lord.
They cannot construct a gate. They have to do it by
I am
taking
not-
your permission.
I am not on
Then-
that point that they cannot. My lord, my humble submission, my lord, there was an altar, my lord, on this point. There was a banyan tree, more than 100 years.
It is
On
not there right now.
few days back, just fell down, my lord. Just few
Fell
days.
down, now it is gone.
Yes.
Yes. So remove the temple.
If your lordship passes that order.
Yes,
my lord,
yes, certainly.
This is the Lord nature of my land. My landed friend is telling me that this is the blood, the water body.
Show it to your learned friends. Show it to your learned friends.
Inside this is the inside of my land. There is no water body, sir.
I am ready to pay the cost if someone goes, I personally visited the spot.
If
found-
Mandir is
My
over
learned
there and
friend-
you say it's a water body,
My learned friend submission, I am just putting on that point. I am not arguing with you.
the construction is there.
Construction is there. Let them enjoy the construction. My temple.
Your temple.
Sorry.
Yes,
sorry,
you all go to
sorry,
this
sorry,
extent.
sorry,
No, this is the real thing.
Sorry for this, my lord.
Yes, it
But
is not
after all,
temple.
After all, we are, my lord, human being, my lord.
Yeah,
We have
everybody.
some
Your learned
sentiment,
friend is also human being.
Everything, my lord, that kind of.
Your learned friend is also human being. He has not come from Mars.
Well, he has the place, entrance and exit, everything is there.
Everything
Only
is there.
A portion.
Why will this portion be blocked?
Well, since long, my lord, they knew after that, knowing everything on as is basis, they have purchased the plot. They knowing everything since last 70 years, it is there.
You tell your clients to construct the building, the mandir at their own private place.
It is no man's land. It is not. They can.
No man's land?
No.
No man's land? Who are you to occupy it? Who are you to occupy it?
Since long back, it is going on.
Who? How many generations are there? Your generation is there.
Last 70 years. It is a local area, my lord.
Local area. He is also a member of the locality.
If your lordship passes such order, my lord, I will
certainly
bow down to accept it.
The number of members standing over here gives a very clear indication as to what is going on over there. It is very evident. The court has not come from somewhere else. I have been moving around the corridors of this court for the last 27, 28 years.
From the appearance
right?
of lordship coming to the conclusion, my lord.
Then it has to be.
They are all employees, my lord, of the central.
Employees of the mandir.
No.
Then
State government.
State government employee, what the person is doing over here? He doesn't have any work. Then
may I pray one thing?
Have they taken leave? Bring your clients. I want to see where they work.
They 2 to 3 persons have their own shop just near the temple.
Yes. So I told you that this is a mode of generation of revenue.
No, my lord. As your lordship, my lord, perhaps my lord, it has not been conveyed by me, my lord.
Very nice. The message is very clear.
Lord, one more photograph, Lord. I don't want to.
Let the municipality do all these things. What is required, my lord? They should assess. They should hold a hearing.
Hearing. Who constructed this? Will you tell me? This is an absolute new construction. Who maintains this?
Generally, local people, my lord.
Local people. Where from does the money come? From tolas.
Required, my lord.
Money is not required.
The subscriptions, 1 rupees, 2 rupees, 5
1 rupees, 2 rupees, tiles, marbles are coming. Where from?
Your lordship, from the photograph, it will not be apparent, my lord. It is only I am submitting of 2 to 3 feet, my lord, wide, 6 to 7 feet length. How much money is required in lordship? When the 1200 applications are there, they are saying if 1200 persons, if they give 1 rupees, 100 rupees, what will the amount?
Yes.
Does it require more than 10 to 15,000 rupees for this, putting the marble and all this?
Go put in the marble somewhere else, not blocking the public road.
It is not blocking, my lord. Wide road, what is in the municipal plan, that road is there, my lord. There is no disturbance to anybody.
There is certainly disturbance. This is a road and you have constructed a mandir in the middle.
Not on the road.
It is on the road. The photograph is very clear. Look at the photograph over here that has been handed up. You can see the road in front and see the mandir.
Road in front. No,
what does it mean? If the mandir is removed, then the road becomes clear to the passengers.
Thereafter, there are no road. Continuation of road is not there.
Added advantage for you.
Is not there,
nothing. The court is not convinced with your submission. The illegal construction is yet to be demolished. Stop. Learned advocate representing the Vidhannagar Municipal Corporation submits that as per the direction passed by the court on 10th of April 2023, notices were affixed in the outer wall of the unauthorized construction. Stop. Nearly 1,200 applications have been filed, not application, make representation, has been filed, claiming that they are responsible for raising the said construction. Stop. Next. Admittedly, the corporation did not issue any sanction for raising such construction. Stop. Photographs produced before this court clearly shows that the lane/passage has been obstructed by way of construction of the said structure, which is allegedly being used as a mandir. Stop. Next. Any construction that is made without obtaining any sanction from the corporation is to be treated as an unauthorized one and liable to be demolished. Stop. Next. The learned advocate representing the members of the locality seeks to intervene in the instant writ petition and submits that the mandir is in place for quite some time. Stop. The same is not creating any obstruction to the petitioner. Stop. Next. The court has inquired from the corporation on an earlier occasion whether sanction was granted for raising such construction. Stop. As the answer was received in the negative, accordingly, the corporation is duty bound to remove such unauthorized construction. Stop. Next. Is the police a party?
But the direction was given on February 8, 2021.
February 8.
2021, page 2, middle portion.
Well, happy for the state respondents.
My lord's order. Middle portion.
The officer in charge of the Baguihati police station is directed to by order dated 8th February 2021. The court directed the officer in charge of the Baguihati police station to provide assistance to the men and agents of the Bidhannagar Municipal Corporation at the time of demolition of the said unauthorized structure. Stop. Next. The officer in charge of the police station will be at liberty to seek for adequate police force from the senior officer, if required, for the purpose of assisting the men and agents of the Bidhannagar Municipal Corporation at the time of demolition of the unauthorized structure, if sought for.
Yes.
The structure shall positively be removed
Video.
by 2nd June 2023, list on 9th June 2023 for ascertaining compliance of the direction passed herein above.
Right. Will I only extend the time for
Time.
demolition for a week at least. Let me
Uh,
video.
11th of June,
Hello.
list on 19th June.
Hello.
Hmm.
In this matter, I am for the Durgapur Municipal Corporation. madam.
Well, I am for the petition.
In the earlier order, my lord has directed me to call both the parties for inspection and thereafter stop the initial water supply and then give water supply to new fresh water supply. We went there, both the petitioner and the private respondent was there. They cannot show any specific place where we can give the water supply.
So what is to be done now?
No space can be given by them, madam.
No, no, we are ready to.
না রেডি টু বললে হবে না, আপনি পড়ুন আপনারা কি বলেছেন। We are ready বললে হবে না।
Existing water supply line at the residence of Nitai Roy. Right, Nitai is the petitioner or what?
My lord.
Nitai is the petitioner. To give a new water supply connection to the premise of the petitioner on the way is mentioned of the corporation. As well as the defender, and after effecting the existing water connection, there is no scope as both the parties were unable to show mutually agreed alternative path.
No space. No, they cannot show any space.
Well, the opposite party made the objection, perhaps. We are
No,
not.
but then both of you have to come to a mutual understanding as to where the
We
water
are ready to
connection.
compromise, Millard. So far, which path they should show, Millard, we are ready to accept, Millard.
The report says that they could not show any agreeable space where both
Where
the
is the
parties.
private respondent?
They didn't come, Millard, today.
And they will not come.
They will not come.
I think so.
Perhaps, Millard.
Well, they are enjoying the water supply in that place. I think they are enjoying.
They are enjoying.
But the petitioner is also enjoying. You also have an existing water line.
My lord, we have already.
Then you want another one.
No, my lord. The same. They are asking for dismantling this line.
The line from where you are getting water connection.
No, my lord. It has been provided by the municipal corporation.
Yes.
And it has come to directly my land, my lord. They are, my lord, saying that it is the land is belongs to me. So change the path.
Okay.
Perhaps, my lord, it is not their path. Title suit is pending, my lord, where my right has been already established there.
Is the municipal corporation going there to disconnect your line?
My lord, there was a hearing.
Yes.
Given by them.
Right.
As per the hearing, my lord, they said that we shall demolish the stop the connection.
That
stop
we will
the,
not do.
stop the water supply.
Your connection.
My lord. But
That
which
is
has
why
been
you
given.
filed the writ petition.
Yes, that we will not do. If my lord directs us, we will not do that.
Then it's all right.
Let them enjoy it from here.
Annexure P4. Please come. None appears on behalf of the private respondents. Stop. A note has been forwarded by the sub-assistant engineer, assistant engineer, and one Mr. Tushar Kanti Goswami. Signed on 10th May 2023, wherein it has been mentioned that a spot inspection was conducted. on 8th May 2023 with prior intimation to both the parties. Stop. It was revealed that there was an existing water supply line at the residence of the petitioner.
was there.
Stop. There is an existing water supply line at the premises of the private respondents also. Stop. To find out an alternative way through which the water connection may be supplied to the petitioner's land. The parties were requested to show a mutually agreed place. Stop. None of the parties were able to show any mutually agreed alternative path through which connection may be effected in the petitioner's portion. Stop. Next. That being the situation, the Durgapur Municipal Corporation is restrained from disconnecting the water supply line of the petitioner. Stop. In the event any mutually agreed alternative path is brought to the knowledge of the Durgapur Municipal Corporation, then necessary steps will be taken in the matter after giving notice to all the necessary parties. Stop. The writ petition stands disposed.
Well,
Grateful.
grateful.
What's the corporation?
My lord, I beg to appear on behalf of the
Regarding
petition.
item number 18, I'm just praying for a short passover. My lord, I'm led by Mr. Srijan Naik, your lordship. If 10 minutes passover can be granted, your lord.
Why you are there? Yes.
My lord, there was a direction of your lordship to bring the documents, my lord, which the petitioners are relying upon. If your lordship can recollect that this is the matter, my lord, where the petitioner applied for mutation and the KMC recorded its name as owner in respect of the property. And your lordship directed on last occasion to Kolkata Municipal Corporation to produce documents in respect of, my lord, their title.
Lordship, the very outset may be permitted to file my affidavit in opposition. On the earlier occasion, we couldn't file the affidavit in opposition. It was the photocopy of the opposition which was relied upon. And lordship, we have the documents, your lordship.
Which page is it?
Lordship, documents are there with me, your lordship. The inventory list. Of 2007 and 2023. Serial number. Original. Original.
Is it 7 Tiljala Road?
Yes, my lord.
Tiljala Road, lordship.
May I please, your lordship, may we hand over the original documents, not starting from 2007 to 2000 current 23-24. Lord, for every years, Lord, these books, and we are maintaining the record. And Lord,
Then does the authority go there and inspect, or upon which documents were this list prepared?
this was Lord on the basis of the Lord assessment made by Lord our audit department, and that started in 2007. That report is with us.
And
Thereafter,
is it done physically? Is it physically audited?
Lord, that on instruction, everything. Every year, Lord, this audit report has to be prepared in respect of the property and the asset and Lord, the assets corporation is having. and that record has to be, my lord, maintained.
It is mentioned that it is an office of the corporation.
Not office.
It is recorded as land description utilization as office.
My lord, that clarification only our officer, those who have done it, highest authority, they will explain. But we are producing the record to show only this is our instruction that, my lord, starting from 2007 to update, my lord, update. Every year this assessment is, this, my lord, inventory is being made. These books are prepared. We are having, my lord, 24 books. And every year this is being done. And, my lord, this HON'BLE has been, my lord, disposed of in 15, they are saying. And, my lord, up to 15, my lord, Bengal Chemical, and Bengal Chem, they are saying they purchased in 2009. Then, my lord, every year, my lord, this tax was being paid by in the name of, my lord, the Bengal Chemical up to 15. So HON'BLE has never paid it, not even single paisa. And HON'BLE has not been mutated also. Now in that way it was going on. Then all of a sudden, my lord, they have noticed it, and they are saying that it has to be mutated in our name. The question is, my lord, whether Bengal Chemical maintained the record as, my lord, the Calcutta Chemical up to 2015. And, my lord, they claims to have it purchased in 2009. There's from 2009 to 15, there was no, my lord, whisper. Then after 2009, thereafter, lordship, they have, my lord, taken this point, saying that it is owned by them, they purchase it. So, the question of purchase, the question of title, my lord, we cannot dispute it because that record will speak for this. Now, only thing is this, my lord, if they purchase it from HON'BLE has not got it mutated. So, my lord, on the last occasion directed us, you produce a record where from your inventory was made, and that inventory records are being maintained for in respect of all the properties and other things, everything in our books.
But then the corporation has issued tax receipt in favor of Calcutta Chemical in the year 2009. How can that be?
Up to 15. That was going on. How it is, my lord, that is being maintained. Nobody raised any objection or protest. That was maintained. Now HON'BLE never paid it. It was never mutated in the name of HON'BLE.
Forget HON'BLE. Calcutta Chemical is there. Calcutta Chemical is there.
They have disposed of. They are in possession now. My lord, possession is, my lord, BBF. According to our inspection report.
Yes. I can see property tax receipts being collected. How can that be in
the name of Calcutta Chemical?
XYZ, whoever it is.
My lord.
If the property is yours, certainly Mr. XYZ will not come to pay tax. And you cannot also raise bills for payment of tax. How do you overcome this?
My lord, only one submission. I cannot improve our case or factual aspect. We cannot, my lord, narrate at, neither we can add anything, or rather we can, my lord, present if all are available to us. My humble submission is this: the question of, my lord, title or civil dispute, civil in nature, which may require, my lord, elaborate evidence for bringing of records, officials,
Will you
justify.
please come to page 33 of the writ petition? It is annexure P1. Who issued this document? Will you please say? Page 33, the very first annexure of the writ petition.
My lord.
Who issued this document?
This is in the name of Calcutta Corporation, lordship.
So your officer has issued it. Let us see what is written over here. To the owner of the premises number such and such, take notice that the above premises has been assessed at an annual valuation of such and such.
Lordship.
And this is dated sometime in 1998. Right? So the property did not belong to the corporation at that point of time?
No, they never claim so also. 2007 they are saying.
The document
Yes.
at page 33 shows that this was not your property. True? Then I see the property tax receipts. Will you please say as to how you got the ownership of this property? It is not because of the fact that it is recorded in the books that the property becomes yours. There may be a mistake. Which one is a mistake? Issuance of this document, the property tax receipt, or it is the inventory list? You have to think it one way or the other.
My lord, in any case, our resolution submission is this: what authority, my lord, the petitioner VVF to raise all these issues, what is the locus? Because before that, Milord Henkel, before that, Milord, Calcutta Chemical.
Please
Now,
show
my,
me your
my
ownership.
lord, I will submit there are, Milord, hundreds of property in Calcutta, where, Milord, Calcutta Corporation is owning. Even I am told, Milord, Anandabazar Puttika and their entire premises, still in the name of, that's the property of, shown as property of the Milord Calcutta Municipal Corporation. Like that, Milord, there are also 100 very important places. Now, how it has come, Milord, I respectfully submit it's a matter of evidence, and it's a matter of thorough recording of, Milord, Milord, evidence has to be, Milord, recorded. How it came, who had the helm of the affairs, how it was written, and the officer concerned who has, Milord, issued the tax receipt, how he did it, he should be called for, and it is to be analyzed. As a whole, Milord, if it is said that no, it is wrong or it is right, I am not saying so. But what I am on is the entire issue, Milord, absolutely civil in
Get a
nature.
copy of the opposition. Do you all intend to file an objection? I don't know what is there in the opposition. A reply, is there anything or not? I don't know.
They have filed a reply, Lordship.
Reply has been filed.
Only on the last occasion, my lord directed you produce a record. This is your inventory reports where they can also take note of it.
Oh, reply is there. Yes.
Chapter 30.
Yes.
সেটা তো পড়ছে।
Chapter 32. Part of part B of the properties of the law.
Yes. Chapter 32.
Part A, properties of the corporation. Start with section 535. 33, I'm so sorry.
I was thinking.
My bad.
Yes, 33.
So this is properties of the corporation. Well, it starts with section 535. The first part says acquisition and disposal of property. 535 is acquisition of property. 536 is acquisition of intellectual property by exhibit. 537 is procedure with intellectual property cannot be acquired by exhibit. Naturally, when the Land Acquisition Act naturally then the power to dispose of power to take hire or take on lease for property, that's 538. 539 is disposal of property, and 540 inventory of the property. Takes 540. Well, having regard to the scheme of that, only the properties which are acquired, taken on rent or taken on lease can part of the inventory of the property.
আরেকটা দুটো ছিল একটা কপি করে
Well, the kind nowadays, when it's read out for section 540, the municipal commissioner shall maintain an inventory of movable and properties of the corporation in such form and in such manner as may be determined by the corporation regulation. In case of inventory of movable properties, the municipal commissioner shall prepare an annual statement of the restrictions therein and place such statement for the mayor in council. Because the mayor in council shall place statement of the subsection along with his common space for the corporation along with budget. Because these statement of the subsection 2 shall be included in the appendix in the annual report of the corporation prepared under section 41. The one kind of section 41. It is divided into the PCL 2007. This is part of their unit. What is to be done under these circumstances? Page 34 of that annual report of the corporation. As soon as maybe after first day of April every year, and not later than such date as been fixed by the state government, corporation shall submit to the state government a detailed report of the municipal government of Kolkata during the preceding year in such form as the state government may delay. The municipal commissioner shall prepare such report and the corporation shall consider the report and forward the same to the state government with thereon. Copies of the report shall be kept for sale at the office of the corporation. The pausing for a moment, the case of the corporation, 2007, this property is now part of the property of the corporation. My lord, first of all, must be shown in the budget estimate, or an appendix to the budget estimate. That budget estimate for the, because that is the case of revision, the statement gets revised. So that budget estimate has to be produced, or the annual budget has to be submitted to the government. Nothing done, to the astonishment. Because as rightly pointed out by now, kindly take page 35 of the resolution. Very logical mind. As in 2014, 2009. Kindly take page 16.
Page 34 also, 2014, 2015, same thing.
69 is the most recent one.
Yes.
Page 69.
Right.
Again, shown owner. Certainly, my lord, I do not know whether by a typographical mistake or some mistake in the record of the corporation, this property is included in the fixed assets of the corporation. God knows how. Well, as the corporation being a public office, the state is the big part. It is a third system of governance in this setup. So, the corporation is duty bound to disclose as to how they acquired this property. This is a case which is of public law character. This is not a title dispute. Title is with me. Your lordship, kindly take they stand. They stand in the affidavit objection.
Mutation, by way of mutation, title cannot be decided.
Yes, your lordship.
So what is the use of going? But then
the question arises that I made an application for mutation. As soon as I made an application for mutation, somehow the corporation got activated to my detriment. And then only, my lord, for the first time, for the assessment year 2016, 2017, the corporation in the this bill or the property tax bill, whatever, they are the owner and I am an occupier. Then they have to disclose what was the arrangement with Calcutta Chemical Officer. They have to disclose what was the arrangement between the owner, the agency on one hand, and the occupier, because otherwise Calcutta Chemical was a trespasser. Secondly, the corporate personality of Calcutta Chemical got destroyed in 2000. Because of this restructuring, amalgamation, reverse market, this Henkel took over the entire process and the entire thing. Now Henkel transferred this particular property in favor of the division. I have disclosed the deed. Disclosed the deed in my description itself. Can't take the description.
Was this ever considered by the authorities?
The application for mutation. Now, they are passing to by and during the course of hearing, they put.
Has any final order been passed?
No, this is during the course of hearing of
This petition.
and when they produce it, they are saying, the application all they have got is inventory.
Yes, I understood. Now, how is this inventory prepared? That is the question.
It is a question of 308. Two factors work out in 308: public interest and compensation. The lordships are there so many times. Otherwise, the due process of law is not followed. So they have to disclose, otherwise, this kind of erroneous incorporation in the record have to be rectified. And this is how you are picking a business entity who is bringing business to the state. This is how ease of doing business is being ensured in the state. How much GST is earned for the state every year? And on the last occasion, I was told that submission was made on behalf of the KMC that they are taking care of the property.
Please come.
Even they issue trade license from time to time. Well, I think a foreign investment, because this is Henkel arrangement, a foreign investment just stuck because of this kind of erroneous record.
But what small reply, lordships, like it?
Reply
Only
by the respondent.
Only one,
Scope.
because some new area has been opened. Very well. Their representation is also here below last page, 78. Let it be disposed of
The,
by the highest authority.
the matter relates to the premises number 7 Tiljala Road.
Yeah.
Seven Tiljala Road. Kolkata 7 00039. The Corporation of Calcutta, Tollygunge Tax Department. Tolly Tax Department. It's Tolly Tax Department. Issued a special notice under section 180 of the West Bengal Act XXX III of 1951 on 11th January 1978 to the owner of the premises number 7 Tiljala Road, intimating that the premises
Madam, kindly excuse me,
has
Lord,
been assessed
may I take short leave, Lordship?
at an annual valuation of rupees 57,199, and the said valuation is to remain in force for 8 years. Paragraph, the Kolkata Municipal Corporation issued property tax receipt in favor of the Calcutta Chemical Company Limited in 2009.
My lord, before that also, if your lordship kindly see page 38 once.
38?
38. 1982 document, my lord.
The no. Start the paragraph as the Corporation of Calcutta issued the consolidated rate tax bill in favor of the Calcutta Chemical Company Limited for the period April to June 1992.
(1982).
And similar bills were raised for the period 1993. 82 এর আগে 80 দেবেন একটা 80 82 93 বোঝা গেল প্রথমেরটা দেবেন 1980,
Page 40.
82 বলেছিলাম, সেটা 80 করুন। For the year 1982 and 1993. Stop. The petitioner claims that the aforesaid Calcutta Chemical Company Limited changed its name to Henkel India Limited. Stop. The petitioner herein purchased the property along with its assets, liabilities and workers from Henkel India Limited in December 2009. Stop. The Kolkata Municipal Corporation continued issuing property tax receipts in favor of Calcutta Chemical Company Limited till the year 2014-15 by mentioning that the owner of the property is the Calcutta Chemical Company Limited. Stop. Next. After purchase of the property, the petitioner applied for mutation of the same in its name. Stop. The Kolkata Municipal Corporation in May 2016 issued property tax bill wherein it was mentioned that the owner of the property was the Kolkata Municipal Corporation and the occupier the Calcutta Chemical Company Limited. Stop. The amount of property tax required to be paid when the bills were issued in the name of the owner, the Calcutta Chemical Company Limited, remains the same when the bill is raised in the name, bill is raised by mentioning the name of Kolkata Municipal Corporation as owner and the Calcutta Chemical Company Limited as the occupier. Stop. The petitioner sought for information under the Right to Information Act as to how the name of the owner could be changed in the property tax receipts. Stop. Prayer was also made for supplying the copies of documents in support of the alleged claim of ownership and to share the terms and conditions in favor of the occupancy of Calcutta Chemical Company Limited. Stop. There has been no response from the end of the corporation. Stop. A legal representation was also filed before the corporation but the same remained unanswered. Stop. Next. In the affidavit in opposition that has been filed on behalf of the Kolkata Municipal Corporation, it has been mentioned that the property in question is recorded in the list of inventory of immovable properties prepared under section 540 within bracket 2 of the KMC Act 1980. Stop. The same is appearing in the list of immovable properties since the year 2007-2008 till date. Stop. The inventory of immovable properties for the period 2007-2008 and 2023-2024 has been produced in court. Stop. Next. It appears that the SSC number in respect of the subject premises remains the same even when the name of Calcutta Chemical Company Limited was recorded as the owner, and thereafter when the property stood recorded in favor of the Kolkata Municipal Corporation by showing that Calcutta Chemical Company Limited is the occupier. Stop. Next. Apart from the fact that the property in question is included in the list of inventory of immovable properties, the corporation is not able to produce any other document in support of ownership of the said property. Stop. Next. The learned advocate for the corporation has also not been able to satisfy the court as to how a property of which the corporation is the owner could have been taxed for the purpose of payment of property tax from a private individual. Stop. Documents prior to 2014-15 reveal that the name of the predecessor in interest of the petitioner recorded as the owner. All on a sudden, the ownership changes without the knowledge of the recorded owner, and the erstwhile recorded owner is described as an occupier of the subject premises. Stop. Next. It is true that mutation is not meant to decide the title of an individual. Stop. Mutation is merely for the purpose of identifying the person primarily liable to pay tax. In the present case, the ownership of the property stood changed by way of issuing the property tax bills without relying upon relevant documents. Stop. The aforesaid act of the Kolkata Municipal Corporation in changing the municipal records without granting an opportunity of hearing to the recorded owner is not permissible in law. Stop. Next. Prior to effecting the change in the municipal records, the corporation ought to have afforded an opportunity of hearing to the recorded owner. Stop. Next. In view of the above, the Commissioner, Kolkata Municipal Corporation is directed to consider the case of the petitioner after giving reasonable opportunity of hearing.
But or his delegate, your lordship. Kindly.
I do not want to delegate it to anybody. আচ্ছা কি বললাম আমি এটা petitioner in accordance with law after giving reasonable opportunity of hearing to the necessary parties and to pass a reasoned order after taking into consideration all the documents and facts placed before the authority. Stop. Next. The the corporation, the aforesaid respondent shall take specific note of the fact that till 2014, the property in question stood recorded in the name of the predecessor in interest of the petitioner. And property tax receipts were issued in the name of the predecessor in interest. The property could not have been recorded in the list of the inventories of immovable properties of the corporation, and at the same time, tax receipts issued in the name of the predecessor in interest. Stuff. Next. A decision shall be taken in the matter at the earliest, but positively within a period of 8 weeks from the date of communication of this order. The recording in the Kolkata Municipal Corporation regarding ownership of the corporation in respect of the subject premises shall not be given effect to and be kept in abeyance till a decision is taken by the municipal commissioner in this regard. Petition stands disposed of.
My lord, only one thing, my lord. They have already given us one hearing as per the direction of Honorable Justice Shom.
They have?
They have already given us one hearing, my lord.
When?
My lord, after the direction of the coordinate bench, Justice Shorkar's order. If your lordship kindly see my lord, my reply, page 12, that is the order of Justice Shorkar. Page 13, second last paragraph, may I read, my lord? Pendency of the writ petition shall not preclude the Kolkata Municipal Corporation from calling the petitioner and any other interested party for a hearing to substantiate their claims with papers and documents as owner in case the petitioner approaches the authority. At the time of hearing, the petitioner shall entitled to inspect the records, competent authority. Accordingly, my lord, they given us one opportunity of hearing. We went there, and thereafter they, my lord, filed this. There are also, my lord, they produced these documents. This inventory.
Final order has been passed.
No final order was passed. They filed these. My lord, the observation of the Justice Shorkar was that after giving an opportunity of hearing, in the affidavit of opposition, my lord, they will disclose their mind. So that is their mind what they have disclosed in the affidavit in opposition.
Very well. A formal order be passed. The affidavit cannot be quashed. Isn't it? Let a formal order be passed.
My lord, can it be a short period of time instead of 8 weeks? Because, my lord, we are
at the earliest.
8 weeks. That's the earliest time, lordship.
At the earliest, but positively within 8 weeks is the outer time limit. So earliest means. Otherwise, you have to come in contempt.
Grateful, lordship.
Grateful. As far as item number 34 is concerned, my lord.
Item number?
34. Well, I am ready with the report. If the others,
Yes.
if it is taken up tomorrow at a preferential.
Tomorrow you have some difficulty.
No, man.
Then?
If it is at a late hours, I have some difficulty.
Keep somebody here. 34 is a long way to go. We are only in item number 18.
Only 18.
So it will take some time.
Hearing done, every inspection done, everything has been done.
Let the
That matter, my pipelines have been laid out. And my lord, we have already taken inspection and found that we can affect the water supply, as your lordship said.
Let the petitioner come. Nobody is here. What can be done?
As your lordship.
Keep somebody here at least tomorrow.
I'm trying.
Keep somebody here.